Good morning. Can folks hear me?
We can hear you.
Okay, thank you. We're on the record, and the first order of business will be to read the instructions for translations, both in Spanish and English. We'll have the translators do that. Thank you for that. This is the third day of the hearing in Environmental Improvement Board docket number 21-48, which is in the matter of the appeal of air quality permit number 8585, Earth Care, New Mexico, and Linda Marianiello petitioners. We do have public comment scheduled for today at 1 o'clock and 5 o'clock. It is possible that we will be adjourned by one or both of those times. I'm going to give you the instructions, the members of the public instructions for signing up for comment, and we will see who signs up and determine how to proceed if we are completed with the hearing before those times. So in order to sign up to give oral public comment as scheduled today at 1 and 5, please send a chat message to the host of the meeting, or you can email the host at pamela.jones.state.nm.us. It's pamela.jones.state.nm.us. Okay, with that, we are in the rebuttal phase of the proceeding, and we're at that point where the department is presenting its rebuttal witnesses. We did have two emails. I received two emails last night regarding additional exhibits, one from the petitioners and one from the department. I'll ask Mr. Jantz at this point to please identify the exhibits that he intends to offer, and then we'll go from there.
Thank you, Mr. Hearing Officer, members of the board. I'm sorry, Board Member Bitzer has a question.
Yes, we have Mr. Bitzer. You're muted.
Point of information here real quick, if I might, Mr. Hearing Officer. I heard you say Pamela.Jones. I think it's the @ symbol, right? If it's an email.
You're right.
Did I hear it wrong?
Yeah, no, you got it right. Pamela, why don't you give your address so we make sure we're correct?
I just don't want anybody to claim later that they tried to weigh in and couldn't because they followed our instructions.
No, thank you for that. I very much appreciate it. Pamela, why don't you give us your address?
It's Pamela, Pamela .Jones, Jones at state, state.nm.us.
Okay, thank you for that. Okay, let's go to Mr. Jantz.
Thank you, Mr. Hearing Officer. So the two exhibits that we intend to introduce today, Community Exhibit 20 4, which is emissions factor uncertainty assessment from February 2007. This is an EPA document. It was referred to earlier in Dr. Sahu's direct testimony, as well as, I think, Ms. Prim's cross-examination. And then the second exhibit we intend to introduce is Community Exhibit, EIB Exhibit 25, which is simply a copy of the issued permit with sections highlighted.
Okay, Mr. Vihil, have you had a chance to review those exhibits?
Yes, I have, and the department has no objection.
Okay, so I will admit those exhibits. Those exhibits are admitted. And then Mr. Vihil had an exhibit, I believe it was department exhibit, well, it's NMED EIB Exhibit 30. Mr. Vihil, could you identify that for us?
NMED EIB Exhibit 30 is an EPA, let me just read the title of the document, I'm sorry. That is Emission Factors Uncertainty Assessment from the EPA's website, or a document from the EPA's website. It is the EPA's description and disclaimer with regard to the uncertainty report that we'll be hearing about today.
Okay, Mr. Jantz, I know we had a discussion about this yesterday. Do you have an objection at this point to admitting?
No, Mr. Hearing Officer, we don't.
Okay, thank you.
Mr. Hearing Officer, sorry to interrupt, but just before you move on, we had another exhibit that was also admitted. This was the document that I had admitted without an exhibit number, and then resubmitted it later. That's NMED EIB Exhibit number 29. If you recall, I submitted it and you asked me to give it a number, and I did.
Yes, okay. Could you identify that for us?
No, I'll identify that right now. That's the EPA hot mix asphalt plant emission assessment report.
Okay, and Mr. Jantz, do you have any objection to admitting that exhibit?
We don't have any objection, Your Honor.
Okay.
Mr. Hearing Officer.
So NMED Exhibit 29 is admitted. So by my records, those are all the exhibits that were offered last night by email, and they are now admitted. Does council agree with that assessment?
The department agrees with that.
Okay.
Petitioners agree.
Okay, thank you. With that, we will turn to the rebuttal testimony of Mr. Peters.
Mr. Peters, are you ready?
I guess I was not ready. I did not unmute myself. I am ready now.
Okay, no problem. Great. Okay. Thank you so much. So we'll start with Dr. Sahu. The first several questions address Dr. Sahu's testimony. Dr. Sahu said on page 27 of his testimony, quote, "It is more likely that emissions are underestimates," end quote. Would you address Dr. Sahu's statement?
I think you misread the quote slightly.
Oh, I'm sorry. Let me reread that quote. Thank you. It is more than likely that emissions are underestimates.
Okay, thank you. It does not appear that any evidence has been presented that supports that statement. A quick examination of Dr. Sahu's testimony reveals many of the emission factors have units of pounds per ton. In other words, a given number of pounds of pollutant would be expected per ton of production. The emission rates are tied to production rates. Maximum emission rates are tied to maximum production rates. AP42 calculated emission rate values are average emission rates for each production rates. For any given facility, it should be equally probable that emissions are higher or lower, not more than likely. Given the varied types of sources at the facility, it does seem likely that some would be higher and others would be lower. That is where the testing requirements in the permit conditions come in and require the facility to demonstrate compliance with the emission limits. The only evidence Dr. Sahu could produce to support the statement was a training presentation about a drop point equation calculations. The best supporting evidence he could find was not even a peer-reviewed article published in a reputable journal. It is unclear what materials and methods were used in this training example, but the materials mentioned include phosphate rock and bauxite, as opposed to the limestone typically found at gravel crushers and asphalt plants. The training example seems to focus on total suspended particulates, TSP, rather than PM10 or PM2.5. TSP has no air quality standards. Cherry-picked data is not evidence that the board should consider. EPA spends considerable resources gathering and evaluating information in their development of AP42. They also evaluate public comments on each section and try to provide the best basis for emissions possible.
Dr. Sahu said on page 27 of his testimony, quote, "And neither NMED nor AAM has any discussion on how the emission factors from AP42 can represent emissions, not just from normal operations, but also during startup and shutdown or during malfunctions." Can you respond to that?
Section 3 of the application states, no SSM emissions are predicted for this permit application. All control systems will be operational prior to start or shutdown of asphalt production or aggregate processing. Maintenance will be performed during period with no production. Malfunction requires the operations to cease, but EPA guideline on air quality models has this to say about malfunctions on page 5218 of the guideline. Malfunctions which may result in excess emissions are not considered to be a normal operating condition. They generally should not be considered in determining allowable emissions.
On page 27 of his testimony, Dr. Sahu said, quote, "If proper emissions are estimated, there is no doubt that for many of the criteria pollutants, there would be significant exceedances of the NACs, eliminating the need for considering background pollution concentration data, and without the need for considering the nuances of the location of these exceedances and ambient air," end quote. Would you address this statement?
Dr. Sahu has provided no reliable or relevant evidence that emissions will be higher than the values that were modeled. Permit conditions that require verification of the maximum emission rates and other permit conditions related to maintenance ensure that the rates will not be higher. The model is designed to overpredict concentrations, and acceptable methods to reduce the overprediction that were not used in this application may be available that would allow the modeling to demonstrate compliance with higher emission rates. Finally, a predicted violation of air quality standards by the model doesn't mean that actual concentrations would be produced were in violation of standards, because the model has many factors that cause it to overpredict concentrations.
In his testimony on page 30, Dr. Sahu questioned reducing the emission rates of the surrounding source with permit number 3534 from 4.08 pounds per hour to 0.85 pounds per hour. Would you address that question?
The surrounding source in question is LM Concrete Pumping GCP5. The facility has permit number 3534 and uses a general construction permit, or GCP. The database the department stores the surrounding sources in typically stores GCP emission rates at the maximum rate anyone could apply for under that type of permit, instead of the emission rates applied for by that particular facility. This illustrates the high burden of proof that applicants bear to get a permit with respect to modeling. Not only do models combine the maximum emission rates, maximum background concentration, and worst case meteorological conditions, 3 factors that are unlikely to occur at the same time, but they must also find and correct surrounding source emission rates that were recorded at higher rates than what that individual facility is allowed to emit. The statement of basis for this facility has been submitted as NMED EIB Exhibit 20. It states the following on page 1. Maximum production limits for GCP5 facilities are 2,400 tons per year. However, the applicant has registered as a small facility. Paragraph IE of the permit smaller than 360 tons per year. See large and small facility applicability requirements in table I.E1 of the GCP5. So if we look at those numbers, 360 divided by 2,400 equals 0.15, or 15%. The facility in question is only allowed to produce 15% of the emissions of a maximum size facility permitted under General Construction Permit 5. Emissions at this type of facility are related to production, as seen in the pound per ton emission factors discussed earlier. That would equate to 85% reduction in emissions, since the database listed the emission rates at the maximum for that general permit. The applicant only requested 79.2% reduction in emissions for this source, but 85% would have been reasonable. The email in the record that described the basis for this reduction is at Bates 001729. Dr. Sahu reproduced the email in his report on page 29, which says the reduction, quote, will account for the fact that it is a small GCP5 facility limited to 360 cubic yards per day instead of 2,400 cubic yards per day, end quote. These values are the same as the facility production limits in the statement of basis for that surrounding source. This is a good example of the modeling system design in its entirety. There are many default factors or settings that are designed to find the highest possible concentration. The applicant might have corrected many more errors of this sort and found other applicable ways or other acceptable ways to refine the model. Doing so would have produced lower predicted concentrations that did not appear to be so close to the air quality standards. The applicant is not required to spend time making additional modifications to the model after they have demonstrated that there will not be violations of air quality standards.
Dr. Sahu pointed out a confusing question about ambient air in his testimony on page 30. Would you address that question?
I appreciate Dr. Sahu for pointing out a confusing question in the hearing transcript. That's in the final Sahu report on page 30. I'll be quoting. He said, NMED's following assertion during day 1 of the hearing is confusing. Question. So the applicant in this case can exclude its own emissions from what would be another facility's non-ambient air. Is that what you're saying? Answer. Yes, and the facility can't prohibit a neighbor from installing close to them by without by using the non-ambient air against them if they were using non-ambient air for their own facility to get their permit. That's it's not clear whether it's in this question.
Mr. Pierce, I just want to be clear. That was an end quote. You're done with Dr. Sahu's quote at this point?
Yes, and that
Okay,
was
thank you.
from hearing transcript day 1, page 258. It is not clear whether it's in the question referred to the applicant or the other facility when the question is taken out of context. I interpreted the question to mean the applicant can exclude the other facility's own emissions from that other facility's own non-ambient air. The answer to that question is yes, and is consistent with EPA definitions and guidance. The answer to the applicant can exclude the applicant's own emissions from another facility's non-ambient air is no. The rest of the response attempts to describe the situation where a neighboring facility previously acquired a permit and used the ambient air definition to exclude concentrations predicted within its own fence line. The non-ambient air for that facility does not become ambient air for the same facility when a different source is doing the modeling. That means the emissions from each facility are not included when determining concentrations inside that own facility's own non-ambient air. The alternative, which is not the way the regulations and guidance operate, would be that each facility would prevent others from constructing in a large area because the first use the definition of ambient air.
Let's turn now to Dr. Clark's testimony. Dr. Clark makes definitive statements of his model predictions on pages 6, 24, 25, and 29 of his testimony, that the predictions of the model, quote, will, end quote, happen. For example, he says on page 24, quote, NAAQS will be violated. How would you respond to these statements of certainty?
Modeling results are not a representation of the expected concentration. They are the maximum potential concentration that would be expected in the unlikely event that all the conservative conditions input into the model occur at the same time. Each facility in the area would have to be operating at maximum capacity at the same time the background concentrations were at the highest and the wind conditions were dispersing pollutants the least amount. Misrepresenting the modeling results as certainty or as highly probable events is likely to alarm the public and mislead the finders of fact. Demonstrating compliance with standards under conservative conditions is a requirement to get a permit, but actual concentrations would be expected to be significantly lower than the values predicted by the model AirMod.
On page 17 of his testimony, Dr. Clark makes the following statement, quote, according to the US EPA's final rule on air modeling, Gaussian models like AirMod, quote, estimate near field impacts of limited number of sources at a relatively high resolution with temporal scales of an hour and spatial scales in meters, end quote. But what does this statement mean?
Just to clarify, the quote was of meters, not in meters. And
Thank you.
The quote itself is vague and non-specific. It must be read in context to understand what is meant by meters. The section is a very general comparison of different types of models. My impression of the discussion is that they are trying to differentiate Gaussian models, which tend to use units of measure of meters for grid spacing, and Eulerian models, which tend to use units of measure of kilometers for grid resolution. AirMod is not mentioned specifically in the discussion, and the probability density functions used by AirMod are not exclusively Gaussian, as bi-Gaussian distributions are used in some situations. Here's the full quote and a quote from the next page that helps provide context. This formulation allows Gaussian models to estimate near-field impacts of a limited number of sources at a relatively high resolution with temporal scales of an hour and spatial scales of meters. Eulerian models assume that emissions are spread evenly throughout each model grid cell. At coarse grid resolutions, Eulerian models have difficulty with fine scale resolution of individual plumes. That's the end of the section I'm quoting. The vague quote in itself does not contribute to the discussion of what receptor spacing to use for AirMod. The absence of a better justification for the use of 10-meter spacing is revealing, however.
Dr. Clark referred to Community EIB Exhibit 20 during his discussion of receptor spacing. What is your analysis of this document?
The introduction to this document contains the following language. This checklist does not constitute new EPA policy and does not offer new guidance recommendations.
Mr. Peters, could you give us a quote and end quote just for the benefit of the public and the board members of the hearing officer and the future court reporters, just so everyone's clear when you're quoting. Sorry to interrupt. Thanks so much.
Yeah, thank you. Quote, begin quote. This checklist does not constitute new EPA policy and does not offer new guidance recommendations. Rather, it highlights important aspects of an air quality analysis with appropriate references to existing EPA policy and guidance to assist in the development and review of the compliance demonstration modeling as part of the overall air quality assessment, end quote. Page 9 of this checklist says the following, quote, modeling domain and receptors. Please reference the guideline, section 8.1, for specific requirements used in the establishment of the modeling domain and receptor grid for the compliance demonstration modeling, end quote. The guideline is EPA's revisions to the guideline on air quality models 2017 that was referenced last question. Since the checklist contains no new guidance and only references to existing guidance, the requirements for receptor spacing must be found in section 8.1 of the guideline. Section 8.1 of the guideline is aptly titled, quote, modeling domain, end quote, and is on page 5217. A careful examination of this section reveals exactly one distance requirement. This requirement basically says that the impact area for Gaussian dispersion models should not exceed 50 kilometers. No requirements for receptor spacing are included anywhere in the guideline that supposedly contains those requirements, or Dr. Clark or I would have found them. Now let's return to the checklist. A parenthetical expression of 25 meters from a document that indicates it is not guidance does not give Dr. Clark the authority to impose the requirement to use 10 meter spacing on the facility or on the department.
On page 7 of his testimony, Dr. Clark says, quote, NMED testimony that reducing the receptor grid distance beyond 50 meters would result in false/abnormally high values is unsupported in the literature or guidance from authoritative bodies such as the EPA, end quote. Could you address this statement, please?
EPA carefully left the specifications of the receptor spacing out of their guidance, leaving the determination of requirements to the modelers at the local agencies. NMED has established that 50 meter spacing will satisfy the modeling requirements and lists that value in their guidelines. Dr. Clark is correct that the department will accept smaller spacing from an applicant if they choose to go beyond the established requirement. Dr. Clark is also correct that the model is capable of calculating concentrations at distances smaller than 50 meters. Dr. Clark suggests imposing the requirement to use 10-meter spacing on the applicant, which is contrary to the NMED guidance. 20.1.2 20.2. Sorry, let me start that number again. 20.1.2.302 New Mexico Administrative Code states, quote, in a petition hearing, the petitioner has the burden of going forward with the evidence and of proving by a preponderance of the evidence that the facts relied upon to justify the relief sought in the petition, end quote. Dr. Clark has not presented any evidence of an EPA requirement to use 10-meter spacing. Dr. Clark has not presented any evidence that 10-meter spacing will produce more accurate concentrations than the 50-meter spacing the New Mexico guidelines recommends. There are any number of ways to adjust the model inputs to create higher or lower concentrations. Reducing receptor spacing and reducing detection thresholds for calm hours are two ways to increase concentrations. When EPA introduced air minute, which would allow lower wind speeds to be input into the model, someone objected that EPA first needs to study the databases that went into the making of AirMod to see if those smaller wind speeds would be supported by the evidence. EPA responded by examining the evidence and making recommendations on minimum wind speeds for use in AirMod. Dr. Clark has presented no evidence of anyone doing a study to support reducing receptor spacing beyond historical values as a requirement. In other words, we know the model predicts higher concentrations when the receptors are closer together, but we have no evidence that those higher concentrations are real. If the model is more accurate at the receptor spacing that has historically been used, then reducing spacing would reduce the accuracy. Such evidence would determine whether tighter spacing results in more accuracy or whether tighter spacing is a trick to get higher concentrations. Lacking any evidence to support lowering receptor spacing beyond the historical use, NMED does not have any basis to change its guidance on accepted spacing. The NSR Workshop Manual, draft October 1990, has been presented as NMED EIB Exhibit 21. This document is not current EPA guidance, but does illustrate the historic use of receptor spacing. The manual states on page C40, begin quote, in order to locate the maximum modeled impact, comma, perform multiple model runs, comma, starting with relatively close receptor grid. Excuse me, let me start over. I missed a word. Begin quote. In order to locate the maximum modeled impact, perform multiple modeling runs, starting with a relatively coarse receptor grid, begin parentheses, e.g. 1 or 2 kilometer spacing, end parentheses, and proceeding to a relatively fine receptor grid, begin paren, e.g. 100 meters, end paren. End quote. And on page C67, begin quote, in order to determine the highest total concentrations, the applicant performs a second model run for the southwest quadrant using a 100-meter receptor fine grid, period. The appropriate concentrations from a fine grid run is added to the monitored background concentrations, begin paren, including source G's impact, end parentheses, to establish the total estimated SO2 concentrations for comparison against the NACs. End quote. EPA's own evaluation of the current model, AirMod, compared to the previous model, ISCST3, is another illustration of spacing that EPA historically uses. EPA's publication, Comparison of Regulatory Design Concentrations, AirMod versus ISCST3, CTDM+, ISC prime, June 2003, has been submitted to NME as NMED EIB Exhibit 22. Page 18 contains the following language. Begin quote. 3.6. Receptor configuration for building downwash. A Cartesian receptor grid extending out to 10 kilometers is used in the building downwash analysis. The receptor density varies with 50-meter spacing for the first 500 meters, 100-meter spacing out to 1,000 meters, 200-meter spacing out to 2,000 meters, and 1,000-meter spacing out to 10,000 meters. This matches that used in the original ISC prime consequence analysis. End quote. Building downwash is an effect where eddies caused by the wind over buildings drags pollution down to the ground rapidly. This is an effect that is important close to sources and less important at greater distances. It would be important to use receptors close to each other to evaluate these effects. EPA used 50-meter spacing, the same spacing NMED recommends, as their basis for development and evaluation of these nearby effects.
Dr. Clark discusses using 5 years of meteorological data in his version of the modeling in his testimony on page 26. Could you address this?
Meteorological data is not mentioned in the appeal petition, but Dr. Clark brought it up in his new testimony anyway. Challenges to the meteorology were addressed in day 2 of the original hearing starting at page 482, line 5. In summary, a single year of data used was the single year of data used was most likely to produce the highest concentrations. Out of all the data available when modeling was submitted, the year used was chosen because it had the highest amount of the slow, stable conditions that result in the highest concentrations for this type of facility. Adding additional years of meteorological data reduces the concentration by averaging the results of different years together. Adding additional years of metadata is a technique some applicants use to reduce their concentrations. In this case, the applicant used the worst available year instead of averaging in better years. This saved modeling time, but resulted in artificially higher concentrations. Dr. Clark claimed that his changing of the meteorological data to multiple years resulted in higher concentrations, but he did not appear to test that independently of all the other changes he made to the model at the same time. Ask for proof before believing that claim. I find it far-fetched. It is ridiculous of him to suggest that averaging more small numbers with a larger number will produce an average larger than the larger number. EPA's guideline on air quality models, the guideline, has been cited many times in this hearing. The introduction contains the following language, quote, "It is incorporated into EPA's regulations, satisfying a requirement under the Clean Air Act, CAA, for the EPA to specify with reasonable particularity models to be used in the Prevention of Significant Deterioration, PSD, program." End quote. This indicates that the guideline applies requirements to PSD major sources and does not apply requirements to minor sources like the facility. For the most part, the department follows the guideline when modeling minor sources. However, it is within the department's authority to deviate from the guideline if it wants to. For example, save time on modeling by using 1 year of worst case meteorological data instead of making the model runs many times as long. Page 5223 of the guideline says the following, quote, "The use of 5 years of adequately representative NWS or comparable meteorological data, comma, or at least 1 year of site-specific, comma, or at least 3 years of prognostic meteorological data, comma, are required," end quote. More than a single year is not required for minor sources because the guideline is not a requirement for minor sources. Even if this were a PSD major source, which it is not, the Santa Fe Airport data seems close enough to be considered site-specific, so a single year would satisfy the requirement. Data used was acceptable and appropriate. Dr. Clark claimed that the modeling should have used meteorological data from a time frame after the permit application was submitted in the original hearing by using such future data in his analysis. The department does not agree that an application is flawed if it did not include data from the future.
Dr. Clark presented PM 2.5 concentrations collected at the Santa Fe Airport on page 24 of his testimony in table 9. Could you discuss these concentrations, please?
I compared the Santa Fe Airport concentrations reported by Dr. Clark with the resulting concentrations from the raw Santa Fe Airport data. The resulting concentrations matched reasonably well. There were several large forest fire events in the last few years. I did not evaluate the data to see if those should be excluded as exceptional events. I correlated wind direction with our concentrations to see if the monitor appeared to be unduly affected by construction of a new overpass and new housing a short distance due east of the monitor. Anecdotal evidence from the monitoring staff indicated that uncontrolled dust was frequently seen in that direction. The maximum average directional concentrations were not seen from the direction of the overpass or from the direction of the nearby industrial complex where Associated Asphalt is located. The maximums were from the direction of Greater Santa Fe, which is the same as the direction of the Reynolds building from that airport monitor. Modeling can be set up to provide different background concentrations, which are based on which direction the wind is blowing. This option was not used in the modeling submitted, but this technique would clearly result in reduced concentrations because concentrations were substantially higher when the wind would blow from Santa Fe toward the facility than when it was blowing in the opposite direction. I will discuss the background concentrations in chronological order. The first year presented is 2017. 2017 does not include a full year of reliable data. The department operated a TM monitor at that location for the first part of 2017 and switched to the BAM monitor on March 22, 2017. The TL monitor is not classified as a federal reference method, FRM, or federal equivalent method, FEM, for PM 2.5, so the results are not considered to be accurate. The accuracy of the BAM monitor is acceptable to EPA. The year 2017 should not be considered on its own for a permitting action because at least 1 year of monitoring data is required. The application for permit 8585 was received by the department on November 26, 2019. NMED Exhibit 1 at 6. At that time, the 2018 data and a partial year of 2017 data from the airport existed. The average concentrations of PM2.5 are represented in Dr. Clark's testimony on page 23 in Table 9. At the time of the application submittal, the PM2.5 concentrations available would have been the 10.0 micrograms per cubic meter for the 24-hour period and 4.05 micrograms per cubic meter for the annual period. The annual concentration at the Santa Fe airport was 0.27 micrograms per cubic meter lower than the value from the Runnels building in Santa Fe that was used in the modeling. The 24-hour concentration at the airport was 0.55 micrograms per cubic meter higher than the value from the Runnels building in Santa Fe that was used in the modeling. The concentrations were similar at these two monitors that are both located in Santa Fe. Substituting these airport concentrations for the Runnels building concentrations in the modeling report shows that existing modeling demonstrates compliance with air quality standards without requiring any additional analysis of the modeling itself. The 2019 and 2020 averages would not have been processed at the time the application was submitted, but either one of them would have demonstrated compliance with air quality standards in the original modeling by making no changes other than the change of monitoring station. The 2021 averages were not available at the time the application was submitted or at the time the hearing record was closed in March 2021. It is not appropriate to include them as a requirement for the facility, but I will demonstrate that they would have resulted in a demonstration of compliance with air quality standards. As I said in the original hearing, when a monitor is located close to a facility being modeled, an examination should be done to find out how much the existing facilities impact the monitor. The purpose of this examination is to eliminate double counting of emissions. It is not appropriate to add the fraction of the monitored concentration that is already accounted for by sources that were explicitly modeled. On page 5220 of the guideline, EPA says, quote, background air quality should not include the ambient impacts of the project source under consideration, end quote. A way to find out what the concentration of modeled sources to the monitored concentration is to place a single receptor at the monitor location and run the model. The facilities already exist and contribute to the monitored concentrations. I ran the original model with a receptor at the airport monitor location to predict the concentration there. The scenario I used was scenario 3, but other scenarios would be justified if they produced higher concentrations. Surrounding sources that were very close to the monitor would have caused high predicted concentrations at that monitor that would not be reflected in the area directly adjacent to the facility. So I omitted sources numbered 40 and higher from this concentration prediction. The result was an annual PM2.5 predicted concentration of 1.7 micrograms per cubic meter and a high 24-hour PM2.5 predicted concentration of 5.5 micrograms per cubic meter. The adjusted 24-hour background concentration is 11.33 minus 5.5 micrograms per cubic meter, which equals 5.83 micrograms per cubic meter. That corrected background is then added to the modeled concentration of 24.57 to get a total of 30.4 micrograms per cubic meter, which is below the standard of 35 micrograms per cubic meter. When the 24-hour background concentration is reduced by the portion of the monitored concentration that should be attributed to the sources already in the model, the total is below the max. It is not appropriate to require the applicant to use data collected after the record was closed for the initial hearing. But if that data was considered appropriately for a future application, the facility would demonstrate compliance with the air quality standards. The annual average for 2021 demonstrated compliance with standards without even accounting for the double counting of emissions. The Runnels building monitor use was acceptable for the reasons I described in my direct testimony, but monitor selection in itself would not have changed the conclusion that the facility will be in compliance with air quality standards.
Thank you, Mr. Peters. Since the rest of your rebuttal testimony is concerning Mr. Schneider's testimony, I will stop us here. I have no further questions for you. Mr. Hearing Officer, because I objected to the exclusion of our testimony regarding Mr. Schneider's testimony, I disagree with the contention that Mr. Snyder's testimony was barred outside of certain subjects. We had this discussion later, and so I want to make an offer of proof of the rest of Mr. Peters' testimony and of Ms. Prim's testimony, the remainder of which, rather than give that offer of proof orally, I request that the remainder of both their testimonies be submitted as offers of proof in written form to the record. You're muted.
Excuse me. When do you propose to submit that?
I need to look at the rules. If I remember right, I think the rules say something that it has to be included into the record. So I could, I suspect we will end before 5 today, and I'm going to assume that the record's going to close sometime around 6. So I would submit them and identify them. And I would identify them as NMED offer of proof 1, NMED offer of proof 2, and I could submit those before 5 o'clock today. It would take me some time. I would need to, get them I need to get them in a form that would be understandable to any appellate body that might review this matter.
Mr. Jantz, do you have a response to that, a position on that? Or the petitioners?
Yeah, Mr. Hearing Officer, we would object to that. We would renew our objection to that being included in the record. Mr. Vigil had the opportunity, especially with Ms. Prim, to have that offer of proof earlier on in this proceeding. It seems like that ship has sailed, so we would renew our objection.
Mr. Hearing Officer, I don't think an offer of proof is subject to objections. I think an offer of proof is not subject to the hearing officer's discretion. I could be wrong on that. I'd have to check the rules. But I request that you withhold judgment on that at this point until maybe we could take a recess at some point and take a look at the rules. I think it is non-discretionary. I think the idea is that you raise an objection, and that's where the hearing officer's discretion will come in, and then the offer of proof is the demonstration to an appellate body that the ruling on admissibility was appropriate or inappropriate gives them an opportunity. It preserves your ability to have that reviewed at the appellate level. And I don't believe there's any kind of temporal language that would require the department to raise an objection or give an offer of proof in any particular time frame. So that's my understanding of the rule. I think we should, rather than create more errors, let's take a recess at some point and come back to it.
I'm going to need to review the rules also. We will look at that over the next recess or at some time before we recess the hearing, and I'll make a determination as to how to proceed on the offer of proof at that time.
Okay, thank you. And with that, we pass Mr. Peters as a witness.
Okay, cross-examination by petitioners is the next order of business, and I see Ms. Locke has turned her camera on. Are you going to conduct the cross, Ms. Locke?
I am, Mr. Hearing Officer.
Please proceed.
Hi, Mr. Peters. How are you today?
I'm pretty good. How about you?
I'm all right. All right, so I want to start this discussion kind of right where you stopped it about the airport data. So is it your position now that moving forward, background concentration data from the airport is acceptable for use?
Yeah, well, that's a complicated question. The airport data is certain years of airport data are available for use in certain circumstances. So I would need a more specific question to give more detail.
So it sounded like you looked at the background or at the data from the airport monitor as part of this whole process, and
Yes.
created a background concentration data like number that could be plugged into that chart that you put in the guidelines, right?
Not exactly. I looked at Dr. Clark's numbers, and the numbers like that could be placed in the guidelines in the future. And I verified that I would have gotten similar numbers. I haven't gone through full evaluation of it, but the short answer is those could be used. Those numbers Dr. Clark presented looked like they could be suitable for future modeling applications in certain situations, and it looked like most likely we would find the same numbers that he did.
Okay. And I'm curious about why you're saying they can only be used in certain situations, because there's no qualifier on the current background number that the department provides.
You're asking for an answer to any conceivable situation, and I'm not willing to give an answer to any possible situation. When we get modeling applications, we make specific determinations on these applications. So in general, they would be used, but I'm not going to say that they're going to be useful in all cases. There could be some situation that would require a monitor that would suggest otherwise.
So let me ask you this. The department provides this 9.45 or 32 background concentration PM 2.5 data number for Santa Fe for people applying for a permit in Santa Fe, right?
Right.
And that's broadly used, right?
Right.
Okay, so what's the difference then between the equivalent number from the airport you said you determined? Why can't that be used just like the other number?
The other number is also not expressed, is not also, the other number is not, so the guideline, the modeling guidelines are the starting point of an analysis. So, for example, I believe you quoted section of the guidelines that talked about how to refine monitored concentrations in your. I saw that flash up on the screen sometime in the testimony.
Mhm.
And so a refined number was not used in this case for the well, a refined monitoring concentrations were not used anywhere in this discussion of the airport of the associated asphalt facilities predicted concentrations.
So,
So if someone had taken either of the monitors and done an analysis on what concentrations happen at what time of day or what season of the year, we expect some seasons to have higher concentrations than other seasons. So if a facility doesn't operate in the winter, then they would not, and the highest concentrations occur in the winter, then they would not be included in the final concentration. So monitoring background is a lot more complicated than you're making it out to be, is what I'm trying to say.
I'm not making it out to be anything. I'm asking, there's a number that the department provides, right? It's not a refined number based on what you
Objection,
tell me.
objection. Council is being argumentative and aggressive. I ask that a council dial it back a little bit. This is a technical witness who's here as a courtesy to the board. He is not an advocate. And please don't yell at the witness.
Okay, Ms. Locke, if you could just rephrase your question. I note that the witness also characterized the testimony in a certain way. So let's just both tone it down here and have a technical discussion. Thank you.
Certainly. Sorry, Mr. Hearing Officer. Sorry, Mr. Peters. Let me ask it this way. The number provided in the chart by the department is not a refined background concentration number. Is that right?
That is correct.
Okay. So then there wouldn't be a difference between the unrefined number from the airport that you calculated with the background number that is provided by the department in the chart.
I think what you're trying to ask is, would the airport be used as a general starting point in the future recommendation of the guidelines? And the answer is yes.
Okay. And you're the person that would update those guidelines, right?
I'm one of the editors. I can't claim that I am the one that did the most recent monitoring concentration evaluation, or that I'm the person who is currently working on that evaluation.
Okay. All right, Mr. Peters. So you talked a lot about, comparing concentrations with the Santa Fe data, figuring out that they matched, finding out, that there may or may not be some impacts from forest fire data. You performed correlations with this data, and I'm not the technical expert, so I'm probably not saying this right, but you evaluated all the data, and I'm just curious about when exactly you did that.
I did this probably within the last month.
Okay. And that sounds like a lot of work. So how long can you ballpark how long that might have taken you to figure
I'm guessing half a day, maybe a little longer.
Okay. And this data, is more representative of what's going on. It's more recent. Do you agree with that?
this is more, I agree it is more recent.
than the Reynolds data. And the EPA guidelines require that you use recent data, right, for background concentrations?
The EPA guidelines has a general statement that that recent data should be used. It does not define recent, and that some modeling expert, the local agency has to decide on whether data is effective, and yeah.
Okay. And you've had the airport data since 2017.
No, well, so the full year of airport data was not available. 2017 was not a full year of data from an EPA accepted monitor.
Okay. Sorry. But there was a full year in 2018, right?
Yes,
But none of these calculations to use the airport data were done until 2022.
Objection. This whole line of questioning was gone through on Mr. Peters' previous cross-examination. There is nothing new. This is going over the same ground, and I think it's a waste of time.
Mr. Hearing Officer, we didn't know until this morning that Mr. Peters reanalyzed that data in the last month. That was never said before. And you're on mute, Mr. Hearing Officer. Sorry. You're still muted, Mr. Hearing Officer.
Sorry about that again. I believe this is something new that was explained by Mr. Peters this morning, so we'll allow some questions on it.
Thank you, Mr. Hearing Officer. Let's see. I'm a little curious about this background information, background data concentration information that you got from the airport. Did I hear you right that you said you looked at the data and didn't see an influence on the PM 2.5 data at the airport from what was happening nearby, the construction nearby?
I did not see the maximums. I did see that they were higher, but the highest concentrations were from the direction of the Runnels building, which is where the monitor we used was, and was also the concentrations used in the modeling were also very similar to the concentrations that were available in the 2018 average that Dr. Clark represented.
Okay, so the really the impact of the biggest impact on the monitor was coming from downtown. Is that what you're saying, from the Reynolds building area?
That's what it appeared that that the center of Santa Fe is the contributes more particulate matter emissions to the airport monitor than the nearby industrial park does.
Okay, so then there wouldn't be a reason necessarily to exclude the nearby industrial park from that number?
I didn't say there was no impact. I said there was a higher impact. So the model's job is to figure out what the concentration is at a specific point for specific sources. So if you're saying that the value AirMod predicted at the monitor is an overprediction, then the values predicted near the facility are much more of an overprediction.
Okay. All right, let's talk about the modeling a little bit and the over prediction of the modeling, right? You were talking about Dr. Sahu's testimony, I think, and you said there was no evidence that any of the emissions are underestimated, right?
Yes, he didn't. What, I'm trying to remember the exact words, but yeah, that he didn't. The numbers were averages, and so he didn't present evidence that it would be skewed at this in the modeling domain one way or the other.
Okay. That's right. You said that it was equally probable that emissions would be higher or lower than what was demonstrated, right?
Right.
So then do you agree that there's a 50% chance that the emissions are underestimated?
For each emission unit in the modeling domain, it would be equally likely for it to be higher and lower, and there's a lot of sources in the modeling domain, so we don't expect the average to be higher than the averages predicted by AP42.
Okay. So then, Mr. Peters, it's your position, right, that AirMod overestimates what could be polluted or what could be emitted, right?
Yes.
Okay. I want to show you, I believe it's NMED EIB Exhibit 22. And if I could share my screen, Ms. Jones. And as I'm doing this, Mr. Peters, it's your understanding that AirMod is EPA's preferred air dispersion modeling program, right?
Yes, that is, EPA requires us to use AirMod in these situations.
So,
Okay, go ahead.
thank you, Ms. Jones. All right, and can you see this, Mr. Peters and
I can see it.
members of the board? Okay, Mr. Hearing Officer. All right, so this is NMED EIB Exhibit 22. And just to provide the context, we're talking about AirMod's overestimation, right?
I don't remember what this exhibit is.
Oh, sure. This is the comparison of regulatory design concentrations
okay.
that you referenced. Yep.
Yes.
We go back down to the general conclusions of this report. Let's see. I guess I want to start in paragraph 3 here. And it says, let's see, the current version of AirMod produces much lower maximum concentrations than previous models, right?
Yes.
And
No,
then-
I'm sorry, that was not correct. The current version of AirMod produces much lower maximum concentrations than the screening technique in ISCS T3.
Right, sorry.
We're talking about a screening mode of one model and a regular mode of another model. So
Gotcha.
that's not a fair comparison, but go on.
Okay, sorry, my mistake. Let's see. And then can you tell me, is CDTM plus, that's a modeling system, or what is that?
Yeah, that's another model that it was used for complex terrain, and yeah, basically it's not what is required in this situation.
Okay. And then compared to that, AirMod tends to predict somewhat lower maximum concentrations, predictions being higher and lower than that modeling software's predictions, right?
Correct.
So AirMod really is the best model out there, is that right? Uncertainty and all?
AirMod is the model that we're required to use, and AirMod should be advanced over these older models. So if AirMod produces lower concentrations, then they're more EPA determined them to be more accurate.
Okay.
Higher doesn't mean better.
Accurate doesn't mean better.
Higher doesn't mean better.
Higher doesn't mean better. Okay, sorry. Okay. And I bring this up, and this document came out, I think it was in 2003. Does that sound right to you, Mr. Peters?
The one we just looked at?
Uh-huh.
That sounds about right.
Okay. And I just asked because you talked a lot about sort of the historical uses of the model and the spacing that was acceptable, relying on this 1990 PST NSR document, right?
Right.
And that 100-meter spacing requirement, that wasn't for AirMod, was it?
That was would have been ISCST 3 at the time, and AirMod is the successor of ISCST 3.
Let's see. I also want to talk a little bit about the Florida study you referenced that was provided by Dr. Sahu. Can you tell us, are the methods in the Florida study reliable?
There's no way to know that. It's just someone's PowerPoint presentation for teaching a class. How is anyone supposed to know if they're reliable if they haven't been published or peer reviewed?
And you didn't check in to see if it was unreliable?
I don't think the burden of proof was on me to determine it to be reliable. That the burden would be on the person submitting the evidence to provide reliable evidence.
Okay. And in that PowerPoint, did you happen to notice whether or not they showed their work?
There were a lot of questions that I could not answer after looking at all of the material, including why they gave pictures of transfer point testing when they were talking about doing a drop point analysis.
So then I have a question, because I'm just not clear. You say that the model, AirMod, is sort of designed to run according to historic purposes, right?
AirMod didn't start from nowhere. It evolved from its history is important in its evolution. So I'm not clear what you're asking.
In terms of the grid spacing, right? The 50 meters is sort of the historic correct way to run AirMod.
So it appeared that 100-meter spacing was recommended for ISCST3, and then EPA in its own evaluations of how AirMod is performing compared to previous models, they used 50-meter spacing and not 10 meters.
And today you're saying that it would be okay to run AirMod with a smaller spacing. It's just not required.
Yes, if someone wants to overestimate their emissions or overestimate background concentrations, underestimate receptor spacing. Those are all the people are allowed to make overly conservative assumptions when they submit their model.
So refining it would result in a more conservative assumption.
Yeah, that would artificially increase their concentrations.
Let's see. I guess I'm just confused when you say it would be an artificial, prediction of concentrations. And I understand your position that the EPA checklist doesn't point to anything that requires 25-meter spacing. But why would EPA tell you to predict something artificial?
EPA is not telling us anything. If you look at the guideline, it doesn't say what the receptor spacing is. EPA
Right, but the
document.
checklist suggests 25-meter spacing, so are they just doing that for no reason?
I don't know. I checked the references and it says that, I mean, you maybe you could have checked the references too and seen that there's no reference to 25 meters in the guideline.
I understand that. There's also no reference to 50 meters in the guideline, is there?
There's not.
Right, so
That's
I'm
not the
just,
question. I mean, sorry, you're asking the questions.
Objection, this line of questioning is getting argumentative. Mr. Peters has given his answer. This is the third time we've gone over this issue. It's repetitive and repetition is irrelevant. It's not going to help anyone.
Ms. Locke.
Mr. Hearing Officer, I'm just trying to understand why 50 meters can be okay, even though that's not in the guideline, but because 25-meter spacing is not okay, but included in an EPA document, that's not acceptable.
I think he's already expressed his opinion on that, and I think we are being repetitive here. So please go to another subject.
Okay, thank you, Mr. Hearing Officer. All right, Mr. Peters, you talked about the general construction permit 3534.
Yes.
And you talked about some math that you did to reduce their emissions rate that you talk about in your modeling summary.
Yes.
But that math isn't anywhere in the record, right?
It's, I mean, in the email that was referenced, isn't it?
The math itself, I don't believe is, but let's look at it. Let's see, and I think you said it was Bates number 001729, right? I'll confirm that and show it to you. Okay. Can you see that, Mr. Peters, Mr. Hearing Officer?
I can see it.
Okay. So this is the number you referenced, 001729. Okay.
Yes.
And actually, before I get to this, I just want to clarify, for a general construction permit application, no modeling is actually required, right?
The modeling has been done previously for general construction permits, and individual modeling is not required with submittal of a general construction permit.
Right, and they're just permitted at like a maximum allowable emissions number, right?
There, I'm not sure what they're entered in the database as a number. They have an application form that lists the equipment, and so they're required to operate within their listed equipment.
Right. But what I'm saying is they're not required to do modeling. They can just operate under this expected general construction permit amount that is like a maximum level of emissions for the GCP, right?
The permit is applicable to sources up to a certain production rate. That does not mean that a source that is using that permit can operate up to that amount of production rate. They're limited to the amount that they request.
Okay, but it doesn't require modeling of the facility itself, right? That's what you're saying. I'm just trying to make sure I'm clear on this.
I mean, the modeling that was done for these permits was complicated.
But it's applicable to the GCP emissions limits across the whole field. Like permit 3534 didn't have to submit its own individual modeling.
They did not.
Okay. Okay. So then, all right, this is the email, right?
Right.
And here it says, and this is from Paul Wade, right?
That's correct.
He was the air dispersion modeler for Associated Asphalt.
Yes.
And he says that he completed the revised modeling for that facility using this other number, this reduction in PM 2.5 emissions from 4.08 pounds per hour to 0.85 pounds per hour, as you all discussed, right?
Right.
Okay. And that essentially gets rid of this NACS exceedance problem that was caused by this particular facility.
Yeah, that facility was originally modeled at many times its permitted emission rate, and so adjustments were made in the surrounding sources.
It was modeled many times. Is that what you said?
It was initially modeled at many times its allowable emission rate according to its permit application.
But its
And
permit
so-
application didn't require modeling, right?
That is right.
So, and this, you asked if the math was included in the record, and I just want to kind of look around here. So this is the email you referenced. This is the email from you before you received that email from Paul Wade. Does that look familiar to you? It's from you.
Yeah, that looks familiar.
Okay. And you say you plugged in 360 yards per day into AP42 and made a bunch of assumptions that you've not verified, and the PM 2.5 emission rate did not drop below the number that Mr. Wade modeled, right?
I did not say that.
That's your email.
Oh, it is. Okay. I thought I was thinking of, let's see, yes, when let's see, yeah, so I made some initial calculations and didn't agree with Paul Wade at that point, I believe.
Okay. And there's nothing in the record between that and then this agreement between you and Paul Wade that drops it below the NAC standards.
I mean, that all the information you need is in that is in that last sentence of that, or the last sentence of that first paragraph. It's 360 cubic yards per day instead of 2,400. It's should be obvious that if the emission rate starts at one number, you divide by that ratio and get the new number. We're talking about a surrounding source, not the facility here.
Right, but the surrounding source emissions do matter when you're modeling the facility, right?
That's right.
And I guess there's just, what I'm trying to ask is there anything in the record that explains this number where you got the 360 cubic yards instead of 2,400, or how you did this math?
Yeah, it looks obvious to me. I don't know your different math capabilities.
Mr. Peters, I just have one other question for you. Did you alone write your rebuttal testimony that you wrote or read today?
I had other people look at it to make sure.
Objection. This is argumentative and confrontational. Now, I just want to say that the petitioners in various forms have called me a racist through a press release. I have, and frankly, I'm the only person of color who's an attorney here that I'm aware of, which is ironic. But maybe I'm wrong, but there does seem to be the implication that somehow Mr. Peters has been coached. He wrote his testimony by himself, and I'm flattered that if any attorney thinks I'm smart enough to do that, I am not. I think I've demonstrated that I'm a little bit of a dummy. So I think this line of questioning is aggressive, out of bounds, and this is the third time that there's been these sort of inflammatory statements. And I would say to the board, if a party can't make their case without using inflammatory statements, I would say that the board should take that into consideration.
Ms. Locke, do you have a response?
Regarding Mr. Peters, he's been qualified as an expert witness, and we're entitled to know, what he's reading is his own work and opinion. With regards to Mr. Vigil, I don't believe anyone has ever called him a racist when it comes to me or my co-counsel or our clients. What we did allege was discriminatory practices on the part of the department and how they, went through procedurally last March's hearing, and that's different. So I'm honestly kind of speechless with that piece of it. But regarding the legitimate portion of that objection, I would say that Mr. Peters, as an expert, he's been qualified as such. We are entitled to know whether what he's reading is his own work and opinion.
Yeah, I believe you're entitled to ask him as an expert about the method he used to prepare his testimony. I think that's appropriate.
Thank you, Mr. Green.
Mr. Vigil's comments and your comments, those are essentially testimony, and you haven't been sworn. And I don't think either one of you qualified as experts on the subject. So I'm gonna disregard that. Let's proceed with your last question.
Thank you, Mr.
I believe the question was, did I write my rebuttal testimony?
Yep.
And yeah, so I wrote my rebuttal testimony, and I tried to get other people to look at it to make sure I wasn't saying things that were stupid or things that other people should have been testifying about. I got a tiny bit of feedback on, let's see, I had help get some of the references. Kathy Prim provided some of the citations to me on when I had those missing. And other than that, it's my testimony. It would be so nice if I could find other people to evaluate my testimony and make sure I didn't say stupid things, but it's hard when you're the expert.
I believe it. All right. Thank you, Mr. Peters. I have nothing further for you.
And if I may, Mr. Hearing Officer, I'd like to move to strike Mr. V. Hill's outbursts and accusations of racism from the record. I don't think I understand that you are going to disregard it as testimony, but I would like it stricken from the record. Petitioners would like it stricken from the record.
Okay, I'm gonna leave it in, but just say for the record, I intend to disregard it and intend to recommend to the board that they disregard it.
Thank you, Mr. Hearing Officer.
As well as Ms. Locke's response. So with that, we will move to questions from the public regarding Mr. Peters' rebuttal. There are questions from the public on Mr. Peters' rebuttal. Okay, seeing none and hearing none, we will go to questions from board members regarding Mr. Peters' rebuttal. Ms. Garcia.
Mr. Peters, just have a clarifying question.
You're a little bit quiet.
Sorry,
My,
didn't hear what was just said.
okay, can you hear me now? I need to
Yes.
not look down when I'm talking, I guess. So thank you, Mr. Hearing Officer. Thank you, Mr. Peters. I have a question that I'm going to attempt to simplify all of this. And I would like for you to correct me if I'm wrong in what I'm about to state, okay? So I understand that the petitioners are asserting that you should have used the airport monitor in the calculations for the modeling, and you used the Runnels building monitor instead, and they are asserting that it would have been better had you used the airport monitor. You, I think, just reported that you did go ahead and use the airport monitor and run it to see what it showed, and the results were that in fact the Runnels building did seem to be the more conservative approach. In other words, the Runnels building showed a more worst case scenario than the airport monitor. Is that, I know I'm super simplifying it, but is that a correct statement basically?
Well, yeah, yes and no. There were some concentrations that were slightly higher at airport and some that were slightly lower in airport. For the year that would have been available, there would have been no difference in the modeling and the conclusion that it demonstrates compliance with air quality standards if they were swapped out without doing any other analysis of the modeling. Did that?
Okay, so
yeah, we did.
Go ahead.
Yeah, we did use the Runnels building monitor in the analysis, but yeah, I analyzed the I looked at I accepted Dr. Clark's concentrations that he provided for the airport monitor and found there would be no difference in the modeling conclusions had the year available been swapped out.
Okay, that answers my question. Thank you very much. That's all I have.
Questions from other board members? Okay, I'm seeing no other questions from board members, and I'm hearing none. So with that, we'll go to redirect Mr. Peters. Mr. Vihel, do you have any redirect for Mr. Peters?
No redirect. Thank you.
Okay, thank you. Okay, there being no redirect, I believe we've concluded Mr. Peters' rebuttal. And Mr. Peters, you are excused. Oh, I did want to say for the record that the testimony, and I meant to do this when he went on the stand, his testimony today is given under oath. He's still under oath, was given under oath. He was still under oath from his swearing in from the testimony he previously gave. Just wanted to say that for the record.
Yes.
Ms. Davis.
I just want to thank Mr. Peters for his time the last couple of days. I understand this is a difficult platform to testify on, and it's also a difficult subject matter to explain to a lot of us who are trying to catch up with the topic. So thank you for taking the time and for sitting in that hot seat for as long as you did.
Yeah, thank you all for your attention.
Okay, with that, the next item is the petitioner's rebuttal.
Thank you, Mr. Hearing Officer. Petitioner's first rebuttal witness is Dr. James Clark.
Before you proceed, Ms. Locke, can you just give us the names of your rebuttal witnesses? I had 3 indicated from prior statements. I noticed Dr. Sahu has not been on the call. If you could just brief us on who the witnesses are, that would be helpful.
Certainly, we're actually only going to have 2 rebuttal witnesses, and it will be Dr. Clark and Dr. Sahu
Okay.
joining us soon.
Okay, let's proceed with Dr. Clark.
Thank you, Mr. Hearing Officer. Good morning, Dr. Clark.
Good morning.
I'll just say for the record, Dr. Clark is still under oath.
Thank you, Mr. Hearing Officer. All right, so Dr. Clark, you've been here for the last few days, right?
Correct.
And there's been a lot of sort of confusion about what air modeling is. So in its simplest terms, can you explain what an air dispersion model is, what it does, how it works?
Yes. Yeah. I could read the definition from EPA and what dispersion modeling is, or which is very verby, or I can say dispersion modeling in this case is a predictive tool for estimating the impacts of sources of pollutants. In this case, it'd be the permit holder in the environment. So essentially what the model does is take the source terms, how much is being put out at what time, and distributes it through the community. You as the modeler determine how far out you want to be looking along the way. So there are a lot of variables that go into this. And if I was to then produce the outputs of this, you get a summary table which shows you the concentration that you determine ahead of time. Do I want to look at the hourly value, at 8 hour, 2 hour? The model allows you to do many things. So there's a variety of outputs that you can get. All those outputs represent is an expression of an equation which says particle A is being released and it moves at this rate upward, and the wind will carry it how far during that given time, and what is the direction of that wind. So it is a very complicated math to come up with a simple question of how am I going to be impacted downwind from a source that is emitting pollution.
Right, and you getting more into the model specifically, we know it's air mod. And you heard Mr. Peters yesterday talking about historic uses of the model, right?
Yes, can I beg the board's, I have two assistants here who are making noise. Let me get them out of the room just 1 second and I can answer that question. I apologize. They were guarding me from the air pollution in Los Angeles.
Worries,
So
thank you.
your question was about historical uses of AirMod.
Yes.
So AirMod is just one tool. It is the preferred tool from EPA. It is the preferred tool which is used by regulatory agencies around the country in situations like this to estimate what the impacts of source A are going to be in community B. It also is very robust in that you can add multiple sources together, the different sites next to each other, and come up with a cumulative impact within the community. So it has been used as a predictive tool to see what's going on in the community. As you look through the model, there's three critical elements that go into it. One is how you calculate the source terms. How much is coming out from site A at any particular time? The next critical element is the meteorology. And what you're doing is using historical meteorological data. And that practice of using historical meteorological data is all based on the fact that there are certain weather patterns that occur within an area, and the data that is represented, in this case, it's from Santa Fe Airport, will tell you the variety of wind speeds and directions that you're likely to see in the community. This is important because wind doesn't blow in one direction. Wind blows in a bunch of different directions. In Santa Fe, the predominant wind pattern is from the north, coming off the mountains. The second pattern comes from the southwest, from the airport up towards the northeast. And the third pattern is from the southeast to the northwest. When you look at what's called a windrose, which is a graphical description of how the wind blows, it shows you the strength and the direction that it's all coming from. So that's item number 2 that's important in this. Item number 3 is the spacing of the receptors. The model calculates the concentration at each point. You then take those concentrations and you put them in a graphical user interface to interpret the concentrations between 2 points. If you've got points, let's say that are very far apart, you start with a kilometer. And one value is at 1 and the other value is at 10. If you've got people who live in between, the question becomes, where does that concentration reach 5, if that's your critical value along the way? So all the model does is report to you the input values that you've got and the meteorological impacts, and then gives you a value at each of these points. When you interpret the data, you put up what's called isoplex. You contour the data to say what geographic area is being influenced at this concentration. That's typically what comes up, and it was detailed in my report previously and in this case too.
All right, thank you, Dr. Clark. That's helpful. So yesterday, when you heard him say that there was a 50-meter constraint on spacing in the model, are you saying there is no historical sort of spacing requirement for the receptor grids?
No, there is not. The understanding within the industry and within regulators themselves is that the model is robust enough to accurately represent the concentration at any given point. What you're doing by putting the receptors either closer together or further apart is essentially focusing like a camera on the picture that you're trying to create. So if you've got a finer detail of what's going on in a particular area, you will understand if there's a maximum that you wouldn't see when it's out of focus. That's the spirit and understanding of why you start with a coarse grid and move your way in to try to get a finer value along the way. You can keep interpreting, you can push the receptors closer together, and you could get to a point where you'd have two receptors next to each other where the concentration would essentially be the same. That would be the limit of the model, telling you you're not going to get anything better than that.
Okay, thank you, Dr. Clark. And so,
Oh, I'm
So-
sorry, can I just make
Sure.
one thing clear about that?
yes.
You asked me about history of the model. Originally, the model was created in old programming language, and there was a requirement which took a long time to process something. So if you've only got a field where the receptors are 1,000 meters apart, you have a small number of equations that you have to calculate. As you add more receptors, you make the grid very fine, you increase the computing time. Now, this was a consideration back in the 90s and early 2000s when we didn't have computers that were as robust as they are now. So what used to take days to run can be done in hours. And if you have access to a supercomputer, it can be done in even less time than that. So the issue related to refinement is really came out of the problem of how much time is it taking to run this analysis.
Thank you, Dr. Clark. And so then, do you agree with this assertion that the more concentrated modeling grid doesn't necessarily mean it's a more accurate representation of space?
No, I don't. In fact, the tighter the grid of receptors that you've got, the more accurate you're going to be. With this one caveat that the input values you've got going in actually represent what's going to be occurring out there. And that's in this permit. The permit says you can operate up to this. So you have to take the assumption this is what is going to be occurring during the time. And that's how it's compared against any of these regulatory standards. So it's a one-to-one comparison, making sure you don't go over that value.
All right, and presumably that's something EPA understands, right, in this checklist.
Yes, yes. So the guidance from EPA leaves it up to the modeler so that they can tailor it to the specific needs of that each specific model. So there's no prohibition about what the spacing should be. And at the same time, they give you enough flexibility to say, this is appropriate for this type of analysis.
All right, and you heard Mr. Peters say that this checklist was fake yesterday. Did you not?
Yes, and I would disagree with his characterization of that.
Okay, and just for the benefit of the board, I want to just show where we got it, if that's okay.
Yes.
Where you got
Yes.
it. All right, so I'm going to go ahead and share this.
Objection. I'm going to ask that question and answer be stricken from the record and restated. Ms. Locke's characterization of Mr. Peters' testimony is incorrect. Mr. Peters did not say that the document or checklist was fake. He said it was fake guidance.
Okay, Mr. Hearing Officer, I can reframe it. I think I'm saying pretty much the same thing. But Dr. Clark, did you hear Mr. Peters call the EPA checklist fake guidance?
Yes.
Show you where we got it from. Okay, Dr. Clark, can you see this screen?
Yes.
And it's the EPA website?
Correct. It's this, the Support Center for Regulatory Atmospheric Modeling, or SCRAM. The title is the Clean Air Act Permit Modeling Guidance.
And is this something, you've looked at before and you've relied on before?
Correct.
Ms. Locke, could you identify which exhibit you refer. I'm assuming this is in the record.
So
I,
the,
I'm just not, I can't, find the exhibit numbers for these documents on my screen. They don't come up.
sure, and so Mr. Hearing Officer, this is actually just a web page. It's not an exhibit in the record. I'm just demonstrating where we got the exhibit in the record that is the EPA checklist.
Okay, so
Objection, this is misleading and surprising. This is not the document that she's talking about. This is not the document that Mr. Peters was referring to. This is a completely separate thing, and I think it's highly misleading to the board. I think that, we're going to ask for the original document.
Mr. Hearing Officer, as I said, this isn't a document. This is demonstrating that we got this document from EPA in response to Mr. Peters' assertion that this was fake EPA guidance.
And Mr. Peters did not testify about what's on the screen right now.
based upon the information that I have, it appears that this document is not something that Mr. Peters testified about, so I'm not going to allow questioning on it at this point.
All right, Mr. Hearing Officer, if I could provide perhaps a printed screenshot as an offer of proof for where this document came from to support the fact that this comes directly from EPA, I would submit that to.
Well, what I heard was Mr. V. Hill's objection is based on the fact that this is not the document that Mr. Peters commented on as being fake guidance. And so it's not something that was within the scope of his testimony. So it's not proper rebuttal based upon what I'm hearing.
Mr. Hearing Officer, can I respond to that?
Sure.
This is going to demonstrate where the document came from. So I can click on a link here and it will bring us to the document Mr. Peters spoke about. That's the point of this process, is to show that it comes from EPA. And it's directly within the scope of him saying that it was fake EPA guidance. Fake implies that it doesn't come from EPA.
I'm not seeing the correlation between this document and what he testified about. So I'm going to exclude it.
Okay. Mr. Hearing Officer. All right. So Dr. Clark, I'll just ask you then, did you get that checklist directly from EPA?
Yes, I did.
And it's accessible online from the EPA's website?
Correct. And the splash screen, the link that sends you to the PDF document talks about how this is a useful document for modelers in these type of evaluations.
All right. Thank you, Dr. Clark. And related to this grid spacing issue, I just want to ask, are you familiar with what other states do in terms of refining their modeling grid?
Yes, I am.
Okay, so what states are you familiar with?
I've done models all the way across the country and out of the country. So I am familiar with Arizona, with the issues that related to New Mexico, Hawaii, Alabama, Louisiana, Florida, and the various air dispersion or air quality management districts within California. We don't have one unifying system. That we're broken into air quality districts, and they're allowed to put their own guidance together. So I'm familiar with federal and state regulatory guidelines.
Okay. And so you mentioned Hawaii. Do you know if Hawaii requires grid spacing at 25-meter intervals at the fence line?
Yes, they do. And they say, so let's back up. So the spacing requirement gets tighter down to 25 meters as you get closer to the fence line and out into the community.
And why is that?
My experience with Hawaii, having grown up there, is that people want to have the best assessment of what's going on. They're essentially following guidance from EPA Region 9, and that's the EPA group which covers the western US along the way. And in there, they've determined that 25-meter spacing is appropriate for fence line evaluations and out into the community.
And what about something closer to our home, like Albuquerque, the Environmental Health Department? Do you know what they require with their fence line grade spacing?
I believe it's 25 meters that they allow.
Thank you,
And
Dr.
if you just proceed a little bit to the west, Arizona goes ahead and use 25 as well.
So then presumably EPA's checklist recommending 25 is based on something, right?
It's recommended on good practice and an understanding that the spacing in the model provides a refinement of your understanding of what the conditions are going to be in the environment. That's all that it really does. It doesn't alter the model. It doesn't alter the output. All it does is require more computing time.
All right, Dr. Clark. And yesterday, did you hear Mr. Peters talk about this idea that modeling is designed to predict the worst case scenario, not the worst case scenario?
Yes, I did.
And what do you make of that sentence?
It's confusing at best. And the reality is the modeling should be predicting what the inputs are. And the issue that comes to this is, what are you going to allow as the emission rate at the facility? And if you hold that emission rate constant, then what are the impacts within the community? And that's the assumption that's given to every polluter out there and every permit out there. So when we move down the line to say, does this site have a cumulative impact? Then you can get to the crux of this thing, which is, how do all of these things act together to affect the community? And it is a predictive tool to say, is there a probability that this is going to happen? And given the constraints that we've put on it, yes, there's a probability that this is going to happen.
And
Ms. Locke, I'd like to take a break here in the next few minutes. Is this as good a time as any to break for 10 minutes?
sure, Mr. Hearing Officer.
Okay.
Fine.
Thank you. We will recess and we'll come back. We'll come back at 11:15. Let's go back on the record. Ms. Locke, you can proceed.
All right, thank you, Mr. Hearing Officer. And I'm not sure, it seems like Dr. Clark might be having some WebEx issues, so I don't know if he needs to log back in is what he was saying, but I see him. We can see
Okay,
him.
I can see him also. Let's give him a minute to see if he can get back in.
Yeah, he says he can't see us, so I think he'll.
He cannot see us? Let's give him a few more minutes.
Yeah, he's gonna log back in. Mr. Hearing Officer, I see his name on the screen. I think.
I see him, I'm seeing it also.
I apologize to the board. My computer glitched on me. I'm not sure what happened there. Darn that technology.
All right. Mr. Hearing Officer, may I proceed?
Please.
Okay. All right, Dr. Clark. So we were talking about this worst case scenario versus worst case scenario. And I just want to get your thoughts on this assertion that because the worst case is unlikely, essentially it doesn't, any NAAQS exceedances found with just the worst case modeling don't really matter because it's unlikely that that'll happen. What do you think about that?
I don't think that's in the regulations. I don't think that's the intent or the spirit of the laws surrounding all of this. The question that is before the permit evaluator is there ever going to be a condition where you will get an exceedance? Short and sweet. So taking that forward, you look at the conditions that are allowable and say what's going to happen along the way. So what I demonstrated in my modeling, what I did was take their model and expand it to use 5 years of Met data. And the Met data that I used included 2016, which they had used before, 2017, which was available on the department's website. It's now archived, but they had Met data from 2014 to 2017. Now, when I ran that, the only thing that changed in this model was that the Met data was going from year to year. So it evaluated 2016, 17, 18, 19, and 20 and said, this is what the impact, if you allow this permit to go through at this condition, this is what concentrations will be found out in the environment. Found an interesting pattern that 2016 is actually lower than the concentrations I found in 2017. So I refer you to Appendix E of my report. If you look at across the columns, it gives you a geographic location, an X and a Y location, and it talks about elevation of the height. And then there's an average value, and then the value for 2016 is reported, the maximum 24-hour value, and then 2017, 18, 19, and 20 along the way. So the board can look for itself and say, in fact, 2016 was not the worst case scenario. 2017, the data that was put out there by the department shows that you actually have more at the locations across the area. The only thing that changed was the Met data, not the source terms, not the amounts that's coming out. So I would say that the representation that they evaluated the worst case scenario is not true. Miss Locke, I can't hear you. I think you're on mute.
Sorry. I just want to clarify that when you say you reran the model with all the source terms, except for you used multiple years of meteorological data, are you saying you ran the model just in the exact same way that the department or that the applicant did, right? With the 50-meter grid spacing and the background concentration, all of that stayed the same. But when you used 2016 data, 2017 data for meteorological data, you found exceedances of the ambient air quality standards.
Correct. So this was the multi-step process. Rather than limit it to say, this is only the meteorological conditions that this site is going to face forever. I said, what was the available data that was there? So starting with the assumption that wind directions will change, wind speeds will change, you may get more rain, you won't get more rain, whatever it is. Using the historical data, this has already occurred in Santa Fe. We're not predicting what's going to occur in the future. We're saying this occurred in the past, And if this plant had been operating at the permit conditions that were outlined, this is the impact that it would have. In 2017, all you have to do is look in Appendix E, and you can look across the various years and see there's an increase in 2017 over 2016. Then there are different values for 18, 19, and 20 along the way. So using that, say that's issue number one. Issue number two goes back to the background that we've had a very robust discussion about. And if I heard Mr. Peters correctly, he essentially is saying that the airport data is representative and that one of the strongest influences is from downtown, which is equivalent to saying, you know, it's about the same as the data that we had before. But when you dive deeper into that analysis, and I provided that in the tables, I did a running average of what the department reported to EPA as the values along the way. And this was to demonstrate to the board that the background value is going to change dependent on influences from outside of the sources. So is the area growing? What are they measuring? How frequently are they measuring? And Mr. Peters did a deeper dive to look at specific data along the way. But I would offer to you right now, if you compare, he was saying that the 2017 data isn't representative because it wasn't a complete year. Well, you could say the same thing about 2014 for the Runnels building. But if you compare the two data sets, 2013, 14, and 2011 and 2017, 2018, which represent complete monitoring data, you will see that the 98th percentile average is 10.0 when it's calculated on this running average. That means everything being equal, the estimate that was originally put in by the petitioner is off by 0.65 micrograms per meter cube. And given that the model was so close, those small differences make a big impact on the results.
Sorry to interrupt you, but I just want to clarify, you said the information provided by the petitioner, did you mean the applicant?
I'm sorry, my apology, the applicant. So Associated Asphalt, their consultant ran this model and the department approved it.
And I just want to kind of back it up just a little bit to the first question about meteorological data. Just to be clear, you're saying 2017 was worse than 2016.
Correct.
And that the department had that data, but used 2016 instead.
That data was on their website when I first logged on, and it is now archived. The Met data that they represented is for Santa Fe, included 2014, 15, and 16 and 17. So that was a tool that was available to the applicant and also to the department to evaluate, is there a concern or not? So I'm not sure about this idea that 2016 is worse than 2017. What it's really being based on, where's the map that shows the analytical difference? I'd say the proof is in the pudding. When you run the model and you do it year by year, you see there's a significant difference in 2017 compared to 2016.
Thank you, Dr. Clark. And then you were talking about the background data. So I just want to, if you could just simplify this sort of comparison between the Reynolds data and the airport data, and what you were saying about this average over time work that you did.
So in my written testimony, there are two sections which detail the analytical results. So this was the actual measurements that were reported for the Runnels building from, I believe, 2010 to about 2014. And then later in the next section, I talk about the reporting for the airport site. And what you see is that there are slight differences along the way, and part of that is going to occur just by reporting issues along the way. The way that, especially the way Mr. Peters was talking about, they have the ability to exclude certain data along the way. I would posit that the question of background and what people are being exposed to really needs to be considered with all the data that you've generated to date. So if you start excluding data, using a phrase that's been used before, you're cherry picking what's going on. So for this question, it's, does AAM, using the permit that is in front of us, will it cause some kind of exceedance? And looking at the data that we've got to date, I can say, yes, it will.
And in fact, if I'm remembering correctly, even AAM's own modeling, as it is, flaws and all, demonstrates some max exceedances, doesn't it?
It shows exceedances near the fence line, on the property, and then next door. The question that was given to me was, did the model go far enough? Was it refined enough to show that there would be an exceedance somewhere where the public could come in contact with it? And going back and looking year by year, yes, I demonstrated that's the case. There are a couple of receptor points which were set out by the applicant. This is part of the 50-meter grid. It's not the tighter grid that I put in there that showed that there were these exceedances. But if you hadn't taken the extra step to include all the meteorological data, you wouldn't have seen it. You would be assuming that it's one constant thing.
Thank you, Dr. Clark. And yesterday, in sort of this conversation about modeling, you heard Mr. Peters talk about, you know, the importance of the relationship and spacing between a monitor and its placement and the grid spacing of the model. Can you make some sense of that?
What I took away from that was the question of, is the data that you're generating on a day-by-day basis going to automatically match up with the model data that you've got going along there? The problem with that assertion is that it's never going to be one-to-one, because we don't have the meteorological data for this day already run. We're running off of historic data. So unless the days are exactly the same, and unless everybody is putting everything out exactly in the way they will with the permit conditions, then there's going to be some variability along the way. This is the interpretation that goes on. So you can use models to determine where the most likely maximum concentrations are going to be. And if you're setting up a monitoring program, that's the way that you would use the model to predict where you're going to put the sampler to make sure that you're really representing what's going on. The grid spacing and the rest of it becomes kind of a moot issue after you put a sampler in there. If you're trying to recalibrate based on the grid spacing to the results of the sampler, you're going to be very dissatisfied with it. We typically represent that, are they approximately the same? Are they within an order of magnitude, 10, 20, 30? This is the kind of thing that is a higher level discussion than what's going on in a permit.
Okay, so in this situation where you're doing modeling for a permittee, the monitor location has no relationship to the grid spacing or anything else like that.
It has no impact on the model. You need to flip it around. If the model is supposed to represent real life conditions and you've got enough information to kind of represent what's going on, how close is the sampling data to the actual model results?
Thank you, Dr. Clark. And then, there was not a lot of clarity about the wind direction in the modeling for this case. Can you just explain the way the wind blows in this area?
So when you take the Met data from the airport, which is the preferred metadata for this site. This is what keeps getting represented either on the department's website, or if you go to EPA and you start looking through the SCRAM to try to find some of this metadata along the way. The airport represents the best conditions of what's going on. What we see is a predominant pattern from the north off the mountains, which if you look back to the physics of it all, kind of makes sense. You're going to get some adiabatic flow. At some point, it goes from the high to low, moves from the north to the south. At the same time, there's also a secondary pattern which shows movement from the southwest, so from the airport towards roughly north of downtown. And there's another pattern that shows from the southeast to the northwest. This is all an interesting way of saying the wind doesn't blow in one direction only. The wind will move, and what the model does is take the wind direction and speed at every point in time and calculate the concentration based on that. Is it going this way, and then does it go this way, and then does it go that way? So if the wind speed alters, the model incorporates that into its evaluation.
Thank you, Dr. Clark. And in terms of where the community is situated, does that wind area, oh, I think you're, can you hear me still, Dr. Clark? Mr. Hearing Officer. Can any of the board members hear me? Okay, so it's not on my end. And I think we lost Dr. Clark.
It looks like we did. Ms. Locke, can you contact him and see if we can get this fixed again?
Certainly.
And the department has no objection if his video isn't working, that he appear by telephone.
Thank you, Mr. Behill. He's logging back on, so we'll see. And if not, I'll suggest that he just call in.
Ms. Locke, can you give us a status report on Mr. Clark? I'm not seeing him back
He
on.
says he's logging back in, Mr. Hearing Officer.
Okay,
so
thank you.
It should just be a couple minutes.
Mr. Hearing Officer, while we're waiting for Dr. Clark to return, I took a look at the rules with regard to offers of proof, and because we were offering oral testimony, I'm not permitted to submit the documents to the record. I'll go ahead and accept without conceding Mr. Jance's contentions with regard to the temporal requirements. There is no temporal requirements, but that being said, I don't think that I need to include Ms. Prim in this, because basically all I need to do is give a statement about what Mr. Schneider was going to testify to, and then a brief statement of how our oral testimony would have addressed that. So I'm just letting you know, and that's in the rules, and just that the citation for that is let's see here.
20.1.2.3.4 and MAC. I've also looked at it.
Okay, gotcha. Thank you so much. I just wanted to bring that up. Thank you while we have the opportunity.
Okay, so I believe that's what you're proposing is consistent with the rule.
And if we're looking for something to do, I'm prepared to do that now. And I don't know if Mr. Jantz is here or not, but I'm prepared to do that now if that's an efficient use of our time.
And Mr. Hearing Officer, it sounds like it might be an efficient use of our time because Dr. Clark is having some trouble logging back in. So, or he can call in depending on what you would prefer.
Let's just do that right now. I see Mr. Jantz on. So, Mr. V. Hill, you can proceed with your offer of proof.
Thank you so much. Mr. Schneider was going to testify in his testimony. Let me quote from his testimony. If the decision to approve the permit is upheld by the EIB, many permit conditions should be strengthened to ensure that the permit is federally enforceable and that the operation will comply with applicable air quality standards. And to that end, he offered 21 separate permit recommendations that we wanted to respond to, and were not able to because of the hearing officer's ruling, respectfully. So basically, our offer of proof was testimony that would demonstrate that none of the conditions that Mr. Schneider were offered would have demonstrated any that the permit at issue in this proceeding would account for any type of exceedance of any national or state air quality standards, and that they were irrelevant to this proceeding. So with that, I'll conclude with that. Thank you.
Okay, thank you for that. I believe that's all we need to do with respect to proof is have it entered into the record, which has been done. So the question is, where do we stand with Dr. Clark? Any updates?
Yes, Mr. Hearing Officer, he's calling in or attempting to, so he should be here
Okay.
shortly.
We'll wait a few minutes to allow him to do it. If he can't get back in reasonably promptly, we'll go to Dr. Sahu and have put his on, and then we'll see where we stand after that with respect to Dr. Clark. Just giving folks, Dr. Sahu and petitioners, advance notice of where we might go.
I'm here, Mr. Hearing Officer, so.
Okay. Thank you, Dr. Sahu.
Hello,
Dr. Clark, is that you?
it is me. Again, I apologize. I live in this, I'm not sure what's happening in Los Angeles right now. Maybe it's an indication I need to leave, but my internet just went out and I really apologize for the inconvenience to the board.
Okay, well, it appears as though we have a decent phone, Dr. Clark, so we will proceed with Ms. Locke's questions.
Thank you.
Thank you, Mr. Hearing Officer. All right, Dr. Clark, I just have two more questions for you. One was related to the wind and the way that the direction that it goes. Do you know sort of what that looks like in terms of where the community is situated? Residents are.
So the community is situated southeast of the AAM facility. So it would be in essentially, because the wind mixes all around, there are opportunities where the wind will go from the site directly to the community. And there will be times when it will come from the community over the site and then move materials off site. So the model has already incorporated all of that in it.
Okay. All right. Thank you, Dr. Clark. And one other question. You understand that this is a consolidation of multiple asphalt plants, but does that certainly mean that the impacts of the plants are consolidated as well, meaning that the community is 100% better off if the plants are moved?
What it means is that emissions which may have been dispersed throughout the community are now going to be concentrated in one area. And Ms. Prim talked about a 44% reduction in the emissions. It makes me wonder about what are the current conditions right now. So if it's nearly, if it's 44% higher than what they're proposing, then, and the emission limits are so close to the NAAQS, it really, without doing the math, just a logical interpretation is that it seems like there's more pollution in the environment right now, and that the community is currently being heavily impacted.
And does consolidating it mean that the community won't be heavily impacted anymore?
No, what it means is that the community now has one particular area to focus on and evaluate. The permit conditions are such that it is right on the edge of flipping over. And you know, I demonstrated if you change the Met year, you see an exceedance along the way. So it is illogical to say that the event won't occur, given that we're already using Met data for the area. So there's an indication that if you consolidate the source, you're going to, at those concentration, at those emission rates, we've seen from the historic data, you're going to get situations where they exceed the NAAQS.
Thank you, Dr. Clark. I have nothing further for your direct.
Thank you.
Okay, does the department have cross-examination for Dr. Clark's rebuttal?
I do. Thank you so much. Hello, Dr. Clark. How are you?
Honestly, Mr. Vigil, I'm a little frazzled. I apologize to you in particular. I know we'd rather be able to see each other, but I'm ready to answer your questions.
Well, I'm frazzled too, so we're a good team. Okay, so can you hear me okay? I know you're on a phone and I can hear you pretty well.
Yes, I can.
Okay, so in your rebuttal testimony just now, you testified that you were familiar with modeling practices in Arizona, New Mexico, Hawaii, Alabama, Louisiana, Florida, California, and the city of Albuquerque. Is that correct?
Correct.
Okay. And you said that the city of Albuquerque, the state of Hawaii, and the state of Arizona, um, it is a practice, and I'm using my language carefully because I'm not an expert here. That it is a common practice to use 25 meter receptor spacing with regard to modeling. Is that correct?
Correct. So in the case of Albuquerque, their guidance says that the fence line receptor spacing must be 50 meters or less. So there's an indication that says it can be less than that. And when you look at Arizona, it says for a tight grid, which is closer than a fine grid, use 25 meters. And in the case of the Hawaii, yes, they've gone ahead and said it's appropriate to use 25 meters at fence lines and within the community.
Okay, let's go back to the Albuquerque. So is it my understanding is what you just said was that Albuquerque allows 50 50 meter spacing and under. Is that correct?
Correct.
Okay. And Arizona, they don't require 25 meter spacing. Is that correct?
What they say is if you're going to do a tight, which is closer than a fine, use 25 meters.
Yes. Do you know? And I understand. I don't want to hold you to being the expert for every state. Just the states that you were speaking about. Do you know if Arizona accepts 50 meter spacing?
Yes, they do. Just because the spacing is larger, the suggestion is there's a variety, it's site specific. And let me just tell you that my experience has shown over these many years that as you refine it, you've got a clearer picture of what's going on. You can make assertions with larger spacing, but as can be demonstrated through the modeling, the precision increases at each receptor point. It's how the data is interpolated and graphed, which typically the person looking at it says, well, you know, why am I really concerned about refining the picture that much?
Thank you. But does Arizona allow 50 meter spacing? Maybe that's what I should have asked.
Yes, they do.
They do. Okay, and we know that New Mexico allows 50 meter spacing. I wasn't clear on your answer about Hawaii. I think I know what the answer is, but I want to ask you again, just so I'm clear. Does Hawaii allow 50 meter spacing?
Yes, it does.
It does. Does Alabama allow 50 meter spacing?
From my memory, yes.
Does Louisiana allow 50 meter spacing?
Yes, it does.
Does Florida, I don't want to belabor this. I have two more. Do Florida and California both allow 50 meter spacing?
They allow 50 meter spacing with the understanding that if you want to go tighter, you can. And that's ultimately, it provides the reader and the trier of the fact, in this case, the department, a better understanding of what the impacts are going to be of any particular project at any given point in time.
So would you agree that then New Mexico's policy with regard to the allowance of meter spacing is identical to these states, in that each of these states that we were just talking about, they allow, or they allow 50 meter spacing, but they also allow tighter spacing or smaller spacing? Sorry for the inaccuracies. If an applicant chooses, or if for some reason it would be required or desirable, would you agree with that statement?
So I agree that other agencies will allow the modeler to put tighter spacing in, doesn't prohibit them from doing it, and that it provides extra information to the person who's going to be reviewing the model. limiting the model to a specific value, to say 50 meters is it, doesn't provide the reader on the other end a refined picture of what's going on in the community. It only provides one view, one estimate along the way. Just like you wouldn't use 1 kilometer spacing for a fence line because you'd miss everything that goes in between. It's important for the people evaluating what's going on to have all the information there and to know where the true maximum based on the model is going to be.
Okay, thank you. And yet in your model, you used 10-meter spacing, is that correct?
Correct. And I used 10-meter spacing to provide a refined, you would call it, it's beyond tight, it's super tight, to see where the true maximum was. The issue that was at concern was the fence line modeling originally presented by the applicant showed there were exceedances of the max in the property next door. Now, given what we've already talked about with do you discount it or not discount it, the question was, how high is that maximum there? So I wanted to see where the maximum was, and I put it at a limited set. I looked at the entrance to the property on the western edge of the property, and I believe to the southwest beyond in areas that had high concentrations. So the whole effort of the refining the grid was to see if there was a maximum value that we were missing along the way.
Thank you. And are you aware of any state that requires 10-meter spacing for modeling?
I don't no, I don't know of any state that requires it. If it's presented it to them, they would certainly have the opportunity to evaluate what that impact is going to be.
Yes, thank you. Okay, so if I'm understanding you right, and again, correct me if I'm wrong, it seems to me that the general idea of your testimony, at least in part, is that, and I think you used the analogy of a camera, the focus of a camera, or if maybe that's not the right word, maybe not focus, but the close up, maybe the macro view of a camera as opposed to a general view of a camera, is that the closer in you can take a look, the more accurate that your model will be. Am I understanding that's the sort of general thrust of your testimony, at least on this particular issue?
That would be correct. That is why the applicant started with a large grid and moved on in. It's common practice to refine the model. And we had a long discussion about this in a previous testimony, and Mr. Peters was talking about this as well. I want the board to understand that this is common to go ahead and refine the model to look for where the maximums are going to be, and that it's not an uncommon thing at all. And it really is, as you said, it's about cleaning up the picture and refining where there could be a problem. So it's more information for, in this case, the department to be able to say, these emission rates are going to make us uncomfortable, and there will be an exceedance if one little thing changes along the way. In that case, it was just changing the net data, changed what was going on in the system.
Okay, thank you. And you are aware that 50-meter spacing, although it may not be your ideal, is the result of a refination of this resolution, correct?
Correct, and that the maximum concentrations that I found and reported as violations were from that 50-meter spacing.
Okay, thank you. Now, and I'm going to ask you one or two questions, and I'm not being glib and I'm not being confrontational. If we take your logic that a further refination or a further refining. I don't even I don't even know if refination is a word. Excuse me. A further refining of the model. Why stop at 10? I mean, I mean, why not go to 1 meter or I don't know, centimeters? Why what is the logic of stopping if a tighter resolution gives us more information? Then why not go to the smallest possible resolution possible in every scenario? Is it why did you stop at 10?
The answer for stopping at 10 was that I determined that there wasn't going to be an exceedance in those areas, and that the driving factor in all of this was that the meteorological data was changing and there was your significant impact. So I answered the ultimate question, which is part of this whole thing of, will the conditions that are allowed in the permit create a condition where you're going to exceed the NACs? And looking at the obvious sort areas where there were the maximums, that's the whole purpose of doing the refinement along the way. And you would refine it to a point where you were satisfied that the concentration between 2 points wasn't going to change significantly along the way. That's the short answer to that. But taking a step back, the question is, does the model that is being used as the basis for this permit accurately depict whether there is going to be a violation of the NACs? And the flaw that I saw in there with the use of only 1 year of meteorological data, I mean, I was quickly able to show you in this last written testimony that there is an impact based upon the year.
Okay, thank you. And let's move on. I appreciate your tolerance on that line of questioning. I want to talk about one more thing, one more line of questioning, just a few more questions. In your rebuttal, you stated that there will be exceedances, that you identified a place where members of the public, not business invitees, we had this, well, I won't get into that, but that members of the public could be exposed to exceedances of PM 2.5. Is that correct?
Correct.
And that, based on your testimony, both below, in the proceeding below, and in this proceeding, that place where members of the public could potentially be exposed to exceedances of 2.5 is at the fence line of the facility. Is that correct?
No. It's in the wash, in the river basin that goes under Route 599.
And not at the fence line?
Not at the fence line.
I see. And how long would the person in the wash, supposing that they were in the wash, how long would they have to remain in one place in order to receive an exceedance of PM 2.5?
It's really a moot question, because the idea is, does the model show that there isn't a concentration? This is, in particular, this is in 2017, and the output for this model. The 8th highest value that's reported shows that the concentration would exceed 35 micrograms per meter cubed. And that was including the background values in this. So it's an area that's accessible to the public. It's an area that, if you're asking me to do a risk assessment on this, that's a whole other level of analysis. Are you asking about the dose? Because what this model shows is the 24-hour concentration. The hourly concentration could be much higher and much lower. So depending on the hour and the concentration that is modeled at that point, the dose could be quite significant.
Yes, so there's lots of different scenarios under different conditions, meteorological conditions, and in terms of the capacity of the surrounding facilities and and the proposed facility at issue here. I understand that, and I understand that you think that the question's mute. I respect that. Moot, I'm sorry. I disagree with that respectfully, and I'm going to ask you the question again. So basically, I think what you're saying is that a person would be standing in the wash beneath the highway, I think you said, and they would have to be standing in one place for 24 hours in order to receive that exposure.
If we're talking about a person, yes, but if we're also talking about an environmental receptor, the wash is there 24/7, so that would be receiving it, and any of the plants or anything else, the wildlife, burrowing animal, whatever the case may be. So the constraints of this are, the standard is to say, what is the annual average? That's one value, and then what's the 24-hour average? And I'm presenting you with an analysis and information that says, here is an issue that you need to consider, and that is, outside the boundaries of the facility, you're going to get an exceedance.
Yes, I appreciate that. Okay, let me see here. I think I have no further questions. Thank you, Doctor.
You're welcome.
Okay, that takes us to questions from board members. Are there any questions of Dr. Clark on his rebuttal testimony? Yes, Ms. Davis.
Yes, thank you. A question kind of popped up in my mind during the testimony, and I admit I should have also asked Mr. Peters the same question, but I'm going to go ahead and pose it here. Is there a test to evaluate the validity of your model? And what I'm really thinking of is, oftentimes we'll propose something in the scientific community, heck, even in the legal community, where we want to test our theory. And so we design a test for it to test that validity. Is that done with your model? And can you explain if there is one, how that would work?
So you bring up a very important question, which is how accurate is the model that the applicant provided to the department, and how is it compared against the results that I got by simply modifying the meteorological data along the way. The assumption ahead of time is that AirMod is an accurate reflection of what would occur over time. The constraint on it, the limitation, the uncertainty is that we're using data from the past to indicate what's going to happen in the future. So it is, in this case, if we are holding the emission rate constant and we only vary the meteorology, you're going to get different values along the way. So when the model goes and says, here's the 24-hour average, the 8th highest value, and on January 1st or January 15th, the 24-hour average in this model was 40.09. It is assuming that the model is run correctly and the input values are run correctly. You would, to do, I think what you're saying, how do we validate what's going on? You would need to allow the permit holder to put the facility in and then run it at these conditions, and then we would need to run the model after the fact. Get all the metadata that's going along there, measure everything that's going along, and then we would be able to tell the certainty. EPA represents that AirMod provides a high level of certainty of what the downwind concentrations are going to be. So there's a couple of values that are missing, but ultimately you would, to use a euphemism, you'd be letting the horse out and closing the barn door. You'd be allowing this permit condition to happen, and part of the permitting process is you've got smart people there who's saying this should be acceptable or this shouldn't be acceptable. And then it becomes an enforcement issue at that point. So if the process is give us the limit that we can go and nobody's going to be harmed along the way, monitoring after the fact doesn't seem like it doesn't serve your need to say whether this permit was adequately designed and is applicable to this site. I'm sorry, did I answer your question?
I'm not sure. I think what you're saying, if I'm understanding correctly, is that there's not really a test, that it's based on the model, I forgot what it's called,
Air mod?
Air mod.
Yes.
That there's not really a test once somebody has submitted their data other than to let the facility go into operation and then run the model against what the facility is doing in real time, and then check the validity that way. But like you said, then the horse is out of the barn. Did I understand you correctly?
Yes, that's it. So EPA has enough confidence and the state agencies have enough confidence in the output of the model to say, we represent that if all these conditions are held constant, we can predict with some level of certainty what the concentrations on the ground are going to be. That's the intent of the use of this model. And if there are uncertainties with the input values, if the machines don't operate in the manner that they're supposed to and more emissions come out, or let's say the dust suppression system doesn't work the way it's intended, they run out of water, they run out of energy, whatever the case may be, then you have to take that on good faith that it's going to operate in this way. And EPA is confident enough to continue to use this and recommends in the Federal Register that this air mod model is the one that's appropriate for permitting under this kind of condition.
So if that's, I mean, I understand that's the case with this particular permit and this particular discussion, but lots of things are permitted, or lots of things are modeled every day for this particular industry. So couldn't you take the data from facilities that are already running and air models that have already been modeled and use that data to create a test or an accuracy level for the modeling that could be done now or for a future facility?
That's a very interesting idea, and it would, yes, test the accuracy. The question is how close a representation to what is being permitted here can be measured out in the environment, and can we do a model in time? So what that would require to really get to the heart of the question, what are the emissions going to be over time in this exact kind of configuration, is identifying an equivalent site with equivalent geographic constraints, it's in a specific location with X number of major sources around it in that community there, and having an adequate enough monitoring network, and then going back and going through the data and comparing it against what was going on. So if you know all the conditions, if you can identify a site, a permanent site, and if you have historic data from that site for the modeling, and you have the throughput going on, then yes, it would be a long, arduous study that can be done that could prove up what we've going. But with the assumption that you can have enough similarity between the sites to be able to prove that.
And I apologize for my last question. I realized it was slightly out of scope. I just was trying to see if I understood everything. But as of right now, this current modeling program is, and the way that the modeling was set up is really accepted by EPA across the nation.
Correct.
Okay. Thank you. I don't have any more questions.
You're welcome.
Other questions from board members? I see I've got two. To let everybody know, my intent is to get through questions from board members, and then we'll take a long enough break to allow folks to grab a bite to eat. That's my current intention. We'll see how things go. We'll go to Mr. Honker at this point.
Okay. Yes. Thanks, Dr. Clark, for your testimony and your work on this. I want to go back to the dialogue you had with Mr. Vigil a few minutes ago regarding human health impacts. You said you didn't do a risk assessment. I read your report and conclusions, and I didn't see any regarding projected impacts on human health specifically. I just wanted to make sure my understanding of your work and your testimony is you didn't draw any conclusions on human health and impacts on the neighboring community or any specific individuals. Is that do I understand that correctly?
Yes, you understand that correctly. The task that was given to me was to evaluate the model and determine whether it exceeded the NAAQS standard. The NAAQS standard, the primary standard for the 24-hour concentration, is based on EPA's assessment of human health. So it is, this is the real question that we've got here. Will this be harmful to people out in the environment? And the modeling shows, yes, it will exceed the value which EPA says for 24-hour exposure is unhealthy. The secondary standard, which affects the environment, is much higher. So this is only considering the health impacts, or this standard considers the health impacts only of particulate matter that's 2.5 microns or less. The other pollutants being emitted by the facility include other criteria pollutants. And criteria pollutants were selected and primary standards created because we understand that there are negative health impacts from exposure to all of those pollutants along the way. In addition to that, there's something called the toxic air contaminant or the hazardous air pollutant. Those are the chemicals that we typically look at to say, is there a particular cancer risk? So the asphalt fumes, which are made up primarily of polyaromatic hydrocarbons, the tarry kind of material, are primarily made up of compounds which are known to be human carcinogens. So on one hand, we're looking at a very broad brushed view of, does this exceed the standard, and what is the standard? The standard says if you exceed this, there are potential health impacts from this. And then you can refine the analysis to look into each one of those particular compounds. But that wasn't the requirement within the permit. It was, are you exceeding these max values?
Okay, I just want to make sure I was clear on the extent of your conclusions. So thank you again.
You're welcome.
Ms. Garcia.
Question sort of gets down to, I'd like to sort of whittle down to what can we agree on between the petitioner and the department. The department is basically saying, look, we followed EPA guidelines. We issued this permit completely in line with the guidelines, with the requirements, with the Clean Air Act, with the state Clean Air Act. And it seems to me what the petitioner is saying is, okay, but what you should have done, what would have been safer for the community, is because the applicant came up with a, after the modeling, their results showed that they came so close to exceeding the NAAQS that it would have been prudent to run the grid tighter, look at the MET data, look at everything, and find out whether or not there could be an exceedance. And what Mr. Peters is characterizing is, and he made a statement that I want to see if you agree with this statement. He said, let's see if I'm going to be able to find it. He said that a model is not designed to be accurate. It is designed to give the worst case. Is that, do you agree with that?
Oh, no. Oh, no.
No. Okay. So here's a place you absolutely don't agree. Okay.
Yes. So the model is just a representation of the data. So the model says, what are the input values that go in and what are the outputs? And the outputs tell you what the impact is within the community. So the precision of the model is driven by a lot of things. Spacing, when we visualize it, when we come to the idea of, is there a plume that moves off-site and what the concentrations are, the model is very accurate in its calculations at each receptor point. So it's a function of distance and, I'm sorry, this really gets me excited. It's interesting stuff. It's a function of the distance from the source, the wind speed at the time, and the elevation that goes along the way. When we're talking about this particular pollutant, particulate matter, it is suspended in the air until the point that it falls out. So when you get conditions that there's a lower wind speed, you tend to see it starting to settle and you increase the concentration along the way. The discussion of the building downwash is important to this. As you go to the lower elevation within the river basin, it's essentially the same effect. You're going from a high elevation to a lower elevation. The wind slows down and it starts to concentrate along the way. So the model precision, the output that goes into the numbers that come out are highly accurate based upon the assumptions that you have ahead of time of what the input values are. And then the interpretation of this interpolating between the data points to put the plume out there is a whole other issue along the way. But the points of agreement that I can see are, there's a source, they're consolidating it, they know that they're emitting certain amounts, and then it goes off, we start to diverge. I don't agree with their analysis of the background data, and that has a huge impact, especially since they are right at the highest level possible for these assessments. If you do a year by year, I've provided the board with all the data for those monitoring stations, and you can see that in particular years, if we focused on 2013 for the Runnels building, the 98th percentile value reported by the department to EPA is 12 micrograms per meter cubed, and that the weighted annual mean value was 5. Both of those are higher than what is reported as the background in the guidance. And in the guidance itself, it should be considered kind of not a complete recipe. It's here's what we expect at a minimum, but you should go ahead and, to really prove the point, prove to us that there's no issue along the way. That's where it's falling down. They're not proving the issue beyond a reasonable doubt.
I appreciate that, but let me go back to my original statement, which is the department is basically saying they did indeed follow department protocol. They followed the guidelines. They followed EPA guidelines. They followed their own regulations. They demonstrated that in their, as far as I can tell, they demonstrated that in their exhibits. Do you agree with that?
I agree that they started that way, but when the department advised the use of one Met year over another, they short-circuited what the guidance was. Their own guidance says use a larger data set. And the department made a decision along the way to short-circuit that. So in that case, they're not even following their own guidance.
On the Met data.
On the Met data. And as demonstrated in my report, the Met data has a significant impact on the results.
Thank you very much. That's all my questions.
Oh, you're welcome.
Ms. Sweeney. Ms. Sweeney?
Yes, thank you, Mr. Hearing Officer, and thank you, Mr. Clark, for your testimony. I have a couple of follow-ups on Member Garcia's questions. So first, I just want to make sure I'm clear. You just spoke about looking at the guidance from NMED. Was that specific to the new the air dispersion modeling guidelines for NMED?
Yes, the 2020 guidance.
There you go. Okay, so 2020. So that's what you reviewed when you were developing your report as well, right?
Correct. And in that guidance on page 41, there's a line that says either 1 year representative data which serves as on-site data or 5 years of appropriate off-site data must be used. I'd posit that while the data, the Met data at the airport it's less than 2 miles away from the site, is a good indication of where the wind is going. If you limit the data evaluation to only 1 year, you're not getting the complete picture. And it doesn't serve the reviewer of the permit, or in this case, the board, doesn't serve the board well to say, we're going to set this up a priori to assume that nothing is ever going to change. And the reality is it does change over time, and you need to consider that in your analysis.
Correct. And thanks for pointing me to that page too, because I'm trying to get my head around, you know, to Member Garcia's point, where the department and the petitioner, what, you know, if we could get some consensus as to, you know, what we're all looking at. Are we looking at oranges, or are we looking at apples, to pull in the metaphor from yesterday?
Right.
So in that, thank you for that clarification on the data sets. And I appreciate your explaining how models work. I'm more familiar with water models, but I can see what you're saying in terms of models, and the inputs and the assumptions are really important in running the model.
Exactly, and the constraints that you have with a groundwater model, you know, whether it is the type of soil that it's moving through, or the slope of the the groundwater bearing zone or where you might be pulling water out all needs to be considered in this. So with that in mind, the idea is that the model that we were evaluating had a number of inputs into it, which we're trying to represent most fairly what actually is occurring out in the environment. And that in this case, the department was telling the applicant to limit some of those inputs by saying only use 1 year of net data.
Thank you very much. And it's a little bit interesting when you pointed me to, you know, the page number and the air dispersion modeling guidelines. I see a link there to an EPA website, which actually takes us back to EPA guidance, the SCRAM guidance that we were talking about earlier today. And I guess what I'm getting at too is I'm trying to also reconcile what documents that we are, the department and others are looking at in terms of this particular issue. And so so it takes us back to that checklist that is in the petitioner's exhibits. And so I have a question. I see in your written testimony, you also looked at the New Mexico Air Quality Bureau air dispersion modeling guidelines. Is that correct?
Yeah, that's the document that we just referenced, the October 2020 document that Mr. Peters is part of the authors of.
Okay. And then by just asking, I know you have brought up earlier your familiarity with Albuquerque air quality guidelines. Am I correct in stating that?
Yes, I've reviewed their air dispersion modeling guidelines as well.
Okay, so I want to go to the grid aspect, you know, this difference between 50 or a more finer grid. And I know Mr. Vigil had asked you a number of questions regarding, you know, what is acceptable in other jurisdictions regarding the grid. But I also was looking at your testimony and the guidelines. And I can see in those exhibits that there is some discussion about, let me pull it up here, about the spacing of the grids related to a more finer ability, you know, a more finer grid spacing on the, are you familiar, can you share with us what your understanding of the Albuquerque one is?
Well, so in on page 4 of their guidance, under the refined analysis section, says, if you would allow me to just read a short paragraph.
Yes, sir.
AirMod should be run using a rectangular grid receptor array. Fence line receptor spacing must be 50 meters or less, period. Beyond the fence line, comma, receptor spacing may be increased to 100 meters out to 1 kilometer. If the radius of impact exceeds 1 kilometer, the receptor array spacing may be increased to 500 meters for those areas beyond 1 kilometer. The emission points, comma, buildings, and fence lines should be located using exact UTM coordinates. So in non-modeling language, the guidance is saying, set up your system at a minimum, put fence line receptors 50 meters apart. You're more than welcome to put it less than 50 meters apart. And as you go farther away from the site, we want you to increase, we're allowing you to increase the spacing between the receptors, because in general, what we're looking at, if we just consider the site as a whole, it's emitting pollutants, and the highest concentrations are going to be closest to the source. And as you get further away, just because of the distance and the time that's associated with it, the concentrations will decrease. So the focus is really on the issue of where's the first point of contact outside the facility? And that should be where your maximums are going to be in a normal situation. If there's some kind of weird building or monument in the way which causes an issue, or there's a change in the elevation, that has an impact on the concentrations too.
Thank you for that explanation. So, and did you also review the NMED, the New Mexico Air what we talked about earlier? And I'm looking at that, and on page, let me see, I just had it highlighted. On page, what page number is this? 70 of that. I'm looking at 7.2, step 2, refined analysis.
Let me get to that.
Okay. Oh, wait, let us know when you get there.
Page 70.
Yeah.
Okay, sorry. My PDF is slightly off here. Okay, refined analysis, yes.
So I know that we're under the ROI section, but and in this analysis, it's talking about the ROI, but it's also talking about grid spacing. And
Correct.
Can you explain maybe to the board and myself that first sentence and what your perspective is on that?
So let me read the sentence. The entire area of significance must be included in the analyses for all averaging periods for each pollutant, period. If the ROI was determined using coarse grids, then add fine grid spacing to the potential areas of maximum concentration or concentrations above the standard. So taking those two sentences together, it says, determine how far out the pollutants are going to go over time. That's the importance of the radius of influence. Use the coarse grid to give you an indication of where it's going to be, then go back and reanalyze it using a finer grid spacing to the areas of potential maximum concentrations above the standard. So it's clearly pointing you to the issue of, will this exceed a standard? And it is allowing you to refine the grid to give you sufficient information to determine what the concentrations, the maximum concentration is going to be. So in all of this analysis, they started with the coarse grid and then went down to a finer grid. And essentially, I went and looked at an even finer grid to make sure that we weren't missing something.
Right, and I think in the next section on 7.2.1, item 4, 1V, is that what you're getting at? And I apologize for taking everybody through this. I'm just trying to reconcile all the guidance, and this is an NMED guidance, and then we have, you know, some of the checklists that have been presented from EPA as exhibits by the petitioner, and then Albuquerque references of the Albuquerque and discussion about that. So I apologize for walking me through this and asking this, but so in that one, it says add receptors near areas of high concentration. If these areas are not contained within a fine grid, the modeling must definitely demonstrate that the maximum impact has been identified. Concentration should fall off from the center of the grid. Sorry, that's not the one I wanted to read. There was this one about, oh, here, sorry, 7.2.2, analyze the refined modeling results. Make sure the maximum impacts for each averaging period fall within a fine enough receptor grid to identify true maximums, include fine grids near adjacent sources and in hotspots. And so with that, and I might be comparing apples to oranges, again, using that metaphor, but to me, I think we're all talking about the grids. Am I incorrect in that assumption?
No, ma'am, you are not. So clearly what the guidance is saying is that if you look at the maximum impacts, it's incumbent on the person producing the model and the reviewer to identify, and the guidance is, if you, under point number 1, Roman numeral 1, the true maximums. If you do not assess this with a fine enough grid, you will miss the true maximum. That's the simplest way to look at what's going on. There's a lot of variables that we can throw into this for this discussion, but ultimately what the model represents is the concentration at each one of the predetermined receptor points. If the receptor point isn't exactly at the maximum, you're not going to find that. You have to go back and refine that analysis to get there. You could get the same effect by just moving the modeling domain to that location so that you would keep your spacing, but then you would end up with the true maximum concentration. But you wouldn't know that until you had run the analysis and run the refined analysis. The concentration at what is the true maximum is not going to change in the model. It's just whether you put the receptor at the right point or not.
Thank you for that description. And so, in your opinion, how if the more coarse model, the 50-meter model, it didn't show any exceedances, how would we get to this section where we would say, oh, we gotta do a more refined model? Or did you, or maybe the other part of my question is, was there indication in the model provided by the AAM and the one that was reviewed by NMED to indicate that we need to do a more refined grid or more refined analysis? Excuse me.
Okay, so if I understand your question, was the data that presented to us adequate enough to determine whether there was a violation or not? Is that a fair summary?
Yeah, or you know, an issue with the exceedances.
Okay, so the original the original model that was presented and used as a suggestion as the basis for the permit showed that there were exceedances of the NACs on the fence line that moved into the adjacent property. That adjacent property also happens to have particulate matter emissions, so that combined together, it became an even bigger problem. But because under the guidance, because it's under an industrial site and the public isn't impacted, then they're not going to worry about that. So you have to take a step back and look at the model results and say, there are clearly areas that are more impacted than others. And the question ultimately becomes, did they actually find the maximum in the areas that the public would be exposed to? And I demonstrated through the modeling that was done that when you actually incorporate the real MET data over time, there is a significant impact on the model results. So that's number one. And number two, that depending on where the receptors are located, you will end up with violations in an industrial area, but you also end up with exceedances in an area that's accessible to the public.
Okay. Thank you for that. Yes.
If I could add, I'm sorry. If you blindly follow the guidance and you do it just to 50 meters, then you don't provide the person who's reviewing this or the board with the full picture of what's going on. What we did to use the MET data that they said should be used along the way is well within the guidelines itself, and it's the the question of the ambient background, its influence, and how the Met data impacts this must be considered in the analysis.
Thank you for that. I have maybe just one more question.
Of
So
course.
earlier, I believe I understood from Mr. Peters' testimony, and I might be inaccurate in this, but I understood that NMED, Mr. Peters, had run another model using similar or the data that was presented with the at the airport monitoring station. And I think I heard that it still didn't exceed the NACs. Can you explain to me from your perspective why that why just using the data still didn't exceed the modeling didn't show exceedances?
So if I have to start out by saying I haven't seen Mr. Peters' model. I haven't seen his calculations. So anything that I'm saying on this is just from my recollection of what he described. He was concerned about the background value that is being reported, the particulate matter value that's being reported at the airport. And he ultimately concurred that the most significant impact is coming from downtown, so that the area of the Runnels building, which had previously been the sampling location, and it gave me the impression that he was saying, and he admitted that in the future we may be using this data as the background data. So he was interpreting what the background measurements, what the impact of the particulate monitor at the airport, how much can he attribute to any given source along the way. And he found that the close construction sites, while there was anecdotal evidence that suggested there might be an impact, it wasn't showing up in the analysis that he was performing. So I can't tell you what model he ran to make that assertion. If, let's just say, if he ran the same model that they did before and he didn't change the meteorological conditions and he limited it only to 2016, yeah, he would end up showing the same result, which is not surprising. It is the decision by the department to limit the meteorological data and to not have a fuller discussion about what the background values are, two critical factors in determining what the endpoint concentration are going to be, which ultimately are making this an issue. That if they had used all the available data, then we'd be talking about something else.
Thank you. I appreciate again your time, Mr. Clark. That's all the questions I have for now.
You're welcome.
Do we have any additional questions from board? Okay, seeing none. Oh, I'm sorry, Ms. Garcia.
Thank you, Mr. Hearing Officer. One more question for Mr. Clark. So I'm understanding that the petitioner's issue is that this permit shouldn't have been issued and to allow AA to consolidate and go across the street and consolidate because you feel that there's a likelihood that they would exceed the NACs. So if the board, if the board were to revoke the permit, whatever the term is, then the applicant would keep their old permits. They would stay where they are. They would continue to operate the way they are. So that leaves me to think that what they're doing now is okay, but if they were to go across the street and consolidate, that's when the problem is, because that's, you know, obviously, that's why you're bringing this whole appeal. Do you understand my point here?
I do understand your point, and I think the question that was presented for me to analyze, I can't speak to everything that the petitioners are saying, but looking at the analytical part of it, I can only deal with what the model says and the assumptions that they put into it. Currently, the facility emits 40. All the facilities emit 44% more, according to Ms. Prim. So there is a larger source of pollution in the community, and the question of how valid the permits are for each one of those is something beyond what I was asked to evaluate at this point. But from the logical extent, if the consolidating this creates an air quality issue in this one particular area, and the sources today are some multiple, let's say 1.8 times what is being allowed under the permit, then I would have to say, without modeling, it's my logical conclusion that there's probably a bigger problem today than there will be if it's allowed to stay as it is. So if this is to remedy the bad situation that's there, they haven't gone far enough.
Appreciate that. Thank you, sir. That's all I have.
Are there additional questions from board members? Okay, seeing and hearing none, we will recess until 1:10. Give folks enough time to grab a bite to eat if they want to. We do have one public witness who needs to be leave by 1:15. So we'll convene promptly at 1:10 to allow her full 5 minutes to make her testimony. And we will do that. And then anyone else who signs up, and then we'll go to redirect if there is any of Dr. Clark, and then to Dr. Sahu, who will be our final witness. Thank you.
Thank you.
One for public comment. We're going back on the record for public comment. I understand we have one person at least who has signed up. Can the host identify the person?
Certainly, yes. It's Rachel Wixom. And Rachel, if you could turn your camera on and unmute yourself, the hearing officer will swear you in.
Hello.
Hello, Rachel.
Is that you, Ray? Okay. Ms. Wixom, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please proceed.
All right. The first thing I want to note is I only became aware of this happening through a friend of mine, and was very shocked that there hasn't been any real broad public notice to all communities in Santa Fe, because we're all going to be affected by this pollution. I mean, I'm not a fool. I come from an area where there's a lot of industry in Cleveland, Ohio, where soot would fall on our picnic table in my backyard. You could actually see it. I remember counting pieces of soot, and I became very asthmatic as a result of that. And then we moved to New York, and it increased to the point where it was severe asthma. I was so pleased to move here because I actually got off all of my medication, and that was 10 years ago. I never thought that would happen. Sadly, the end of this year, end of 2021, I ended up back on a mild dose of inhaler. And to me, to add any kind of industry that can affect the pollution in this area, such a populated area, is unconscionable. I just don't understand. Splitting hairs about technicalities makes no sense to me. It just seems a no-brainer. And I'm sorry to get emotional about this, but it affects not only me personally, but people who I know have children. I can count on both my hands the people in the last 5 or 10 years who now are on inhalers living in this area that weren't before. and it's only going to increase. And we only have one set of air, right? And whether it blows left or right or whatever, it's still going to affect this entire community. And I just wanted to mention that I'm actually rather angry that we haven't become, the community at large hasn't become more aware of this and had a better chance to really respond. I just heard about this hearing from a friend of mine like today. I mean, it's just, it's ridiculous in my opinion, and irresponsible of our government and anyone who's involved in this. And so that's what I wanted to convey to you. I was hoping I would be a little less emotional, a little less angry, and more constructive, but it affects all of us and the future of this community. So I do not want this in my backyard. So those are my statements. Thank you.
Okay, thank you, Ms. Wixom. Are there any questions of Ms. Wixom? Yes, Ms. Marianello.
Yes. Rachel, could you tell us where you live in town? Are you a South Side resident or do you live somewhere else?
I'm in Rancho Viejo. So I'm not so far from you all. I mean, I'm not in the fancy part of Santa Fe, but I mean, I'm not stupid. The pollution's going to come our way. It just is. So.
Thanks a lot. Appreciate it.
Yeah, thank you.
Okay. Are there any additional questions for Ms. Wixom? Okay, hearing none and seeing none, thank you for your comments.
Thank you.
And we will go to the host to see if we have other public witnesses at this point.
No one else has indicated they wish to make a public comment.
Okay. Okay, having no other public comment, we will turn to redirect of Dr. Clark, Ms. Locke.
Thank you, Mr. Hearing Officer. Just briefly, I have a couple questions for you, Dr. Clark. You went through the list of states that accepts 50 meters spacing, right?
Yes.
And do you happen to know if all of those states would accept 50-meter grid spacing at the fence line if NACS exceedances were found based on modeling just using 50-meter spacing?
So at the fence line, they would say at 50 meters, you've got a problem here. So tell me what the true maximum concentration is. Just like the department's guidance and the refined analysis says, find me what the true maximum is. That's the crux of what this spacing issue is all about, is that have we actually found where the maximum coming from the site is?
Okay, so if, for example, a permit application was received by the permitting authority in Hawaii, and that application demonstrated NACS exceedances at the fence line based on a 50-meter grid, would that need to be refined?
The permit application would need to be altered because it's demonstrating that there is an exceedance of the NACS. Okay. And what would next occur is that you would refine the analysis to see how much you are going to actually exceed. So if you've got a 50-meter grid and the point in the middle of it is the maximum concentration, but that's not covered by the actual receptor grid, it's not a point that is actually calculated, then it's important. That's why we refine it. We're bringing the grids closer to see where the maximum actually is. The importance on this is that when you're looking at the permit to say how much do you need to reduce the emissions to make sure that the maximum going off site doesn't exceed the NACS. So that's where the refinement process comes in. So if I was the regulator given that information, I would want to know where the true maximum was, and then I could work with the permit holder to say, hey, you got a problem. You need to dial this down.
So at Hawaii, you'd refine the grid.
Correct.
You would refine the grid with a NACS exceedance based on Hawaii's guidance, Arizona's guidance.
those guidances allow for a finer grid, and the sole purpose of the finer grid is to find out where the true maximum is. And that is important when you're considering what are we allowing the source to emit and what will the impact be on the community. I mean, that's really dialing it down.
So, and I just want to be clear, AAM's modeling before various exclusions were, rightly or wrongly made, did demonstrate exceedances at 7 spots along the fence line using a 50-meter spacing.
That is correct.
Okay. And NMED didn't require any sort of refinement after that.
No, they did not. So it was, I would speculate as to why. It seems like it's all about the fact that it was going on to a neighbor's property, and they were assuming that the public wouldn't have access to it.
Well, and that leads into my next question. So you and Chair Sweeney read the guidelines, right? And they essentially say that any permitted facility or any modeling, can't demonstrate that facility will violate any ambient air quality standards in an area where the public has access, right?
Correct.
It doesn't say in an area where, maybe the public might have access sometimes, that's okay.
No, there's no limitation. A standard is set up so that you understand that when you exceed that, there is going to be a health consequence. That's why the primary standards for NACs are set up the way they are. The geographic location of that, as long as it's outside the facility, is the only concern that we have at this point. There were violations to the property next door, and I've demonstrated that there were violations in an area that's accessible to the public. So it's a clear indication that the permit conditions that are in this before the board would create situations that would exceed the NACs.
And that guideline also doesn't say, well, it's unlikely that it might exceed the NACs, so that's okay. If it demonstrates a NACs exceedance, it demonstrates a NACs exceedance, right?
Correct. And that's the purpose of the predictive modeling that we're doing, is through all the various meteorological considerations and through the geographic locations, can you point to a time in space, or a time and space where the concentration would exceed 12 micrograms per meter cubed for an annual average, or 35 micrograms per meter cubed for the 24-hour average? And if we think about the 24-hour average, in any given year, there are 365 different 24-hour periods. So this is a large data set that is being looked at to say, where's this concentration? And the way this is set up, we're consistent with the guidance that it's the 98th percentile value that we're comparing.
So if I was in that riverbed tomorrow and it wasn't exceeding the PM 2.5 NACs, but it would be 20 minutes after I left, is that still considered a problem?
Yes, it's a violation of the standard.
Okay. And then just to clarify your modeling, and this is related to Vice Chair Davis's question. When you ran your modeling, the first thing you did was do the exact same thing as the department. You just changed the meteorological data, and that demonstrated exceedances. Am I understanding that right?
That is correct.
Okay. And then the model itself, AirMod, we've talked about this, it's approved by EPA, but does EPA provide any sort of studies demonstrating that AirMod itself is appropriate for this?
Well, if you look in the federal guidance under Appendix W, there's a whole description of the history and validity of the use of AirMod in this type of analysis. So from the SCRAM website that we started to talk about earlier, there Appendix W is attached, and it's the guidance from EPA, from the federal government, saying these are the models we approve, and these are the constraints that we have on it, and these are the ideas about it, and this is really an appropriate model to be using for this type of evaluation. in there, there are also supplemental documents which talk about the validity of it. So we could certainly go to that and look for the supporting information, which over time, and even in the Federal Register itself, it has references to the reliability of it.
And would looking at these studies help sort of validate the use of the model, the way that you used it and the way the department approves of it and the way the applicant does it?
Yes, it would certainly provide more information for board members to see, taking a step back, is this an approved method? Yes. Is the model that was presented from the applicant fit within the idea of how it's supposed to be used? Yes. What are the limitations on the model? Well, the limitation that was directed by the department was that they use only 1 year of metadata. And that flaw limits the analysis that's being presented there, as well as the consideration of what the true background value is. If we're looking at what is the background in Santa Fe, New Mexico, that's very important when we're considering this. The permit conditions were so high that it was the combination of the background concentration and the metadata which caused it to exceed the NAAQS when we look at the total effect in the community. So that's I would really like the board to be aware of that, and that's why in my report, in my testimony in Appendix C, I presented the metadata that was reported under the Runnels data for the Runnels site historically from, I believe, 2009 to 2014. And then in Appendix D, I provided the same data for the airport. And that's the data that I use to create the running averages that you see in my testimony, in the written testimony, saying this is what the background concentrate, or this is what the average concentration, annual concentration is, and what the 98th percentile is, using the assumptions that are consistent with guidance, that we're running a 3-year average along the way.
And Dr. Clark, I just want to clarify, I think at one point you said metadata from the Runnels building, but you meant background data, right?
I apologize. I'm not doing well today. My internet and everything else. Yes, I was talking about the analytical data that was presented from the sampler that used to be there. And that sampler, remember, we had a discussion early on that talked about that sampler had a limited number of data collected through the course of the year. The airport data collects continuously. So you've got a much broader swath of information to deal with.
All right, Dr. Clark, and one more question, and this is related again to grid spacing. You, in your discussion with Chair Sweeney, you said something about moving the modeling domain, and I want to make sure I understood what you said. Meaning you run a model with 50-meter grid spacing, right, like was done. And if you moved that grid, that modeling domain, 25 meters to the right or left, would you potentially get a different result?
Yes. So if you consider you've got the original modeling domain, and then you take that modeling domain and slightly shift it over. What the model is doing is calculating the concentration at each one of those receptor points. Doesn't make up data. It doesn't add anything new. What it does is calculate the time and distance from the site. So you can get the same effect that I documented with a 50-meter spacing by running it, seeing where the highest concentration is, shifting the grid slightly, running it again, and you'll see that there's a slightly different level of concentration. The value, which is what was done by myself, is exactly what the applicant did by starting wide and going narrower, and you add layers of refinement along the way. This just saves the issue of trying to shift the grid over. It gets very confusing. Is it really at the origin? Is it really at the center of the facility? All sorts of crazy things like that. But in essence, the concentration will change because the distance that we're talking from the source to the receptor point has changed. But if you keep the 50-meter spacing, you're still going to have the issue of, did I find the maximum concentration that way?
All right, thank you, Dr. Clark. I have nothing further for you.
Thank you.
Mr. Hearing Officer, I have a few questions on recross.
Okay, Mr. Vito, let's proceed with that.
Thank you. Dr. Clark, I wanted to follow up on your conversation with Chair Sweeney. To my mind, there was a little bit of a lack of clarity with that exchange. And I just want to clarify. The 50-meter spacing that the department used is itself a refining of their original spacing. Is that correct?
Correct.
Okay, thank you. And can you tell us, or do you recall, and I'm not trying to surprise you here, it's okay if you don't know, do you recall what the original spacing that was used?
In the radius of influence testing modeling
Yes.
that was done?
Yes.
You know, I would be speculating. I'm not dodging the question. I just don't recall at this. I can tell you it was greater than 50 meters. And that's what
Okay.
I was pointing to earlier for the board members, is that in the question to Ms. Locke, that it originally started out with a wide grid. You determine the radius of influence, you bring it on in, but just like section 7.2.2, to analyze the refined model, you're trying to find the true maximum. So there's no prohibition in the guidance that says you stop at 50. You're attempting to find what the true maximum is. And that's the whole purpose of laying on the next layer of refinement.
Yes, I'll just belabor this point. Just one last question on this point, that there was a larger spacing and then it was refined down to 50 meters, and that was what was in the modeling that's at contentions in this case, correct?
Yes.
Okay, thank you. So let's, there was another question that you had, I believe it was Member Garcia, who had asked you a question regarding the purpose of the modeling. Mr. Peters, she paraphrased Mr. Peters' testimony that the purpose of the modeling is to find the worst case scenario. You disagreed with that, and then gave an answer that sort of indicated that the purpose was to find what was really there, or to find the most accurate data possible. Is it possible that there are two competing outcomes here, or two possible goals? In other words, there is a regulatory goal, which would be the creation of a worst case scenario, and then a more academic, research-based goal that was about finding the most accurate data. Worst case scenario could be a regulatory goal, and then an academic research-based goal could be, to get the most accurate data. Is that a correct assessment?
No, I'd have to disagree with you on that, because the purpose of the modeling clearly is to predict what the concentrations are going to be in the environment. I mean, that's the most basic purpose of the predictive modeling. The next layer to that is the regulatory one that you're talking about, which says, how much can we allow this facility to emit and not exceed this health-based threshold? So that's layer number two. The analysis that was done to date demonstrated that there were violations at the fence line moving off-site into the adjacent property. The next logical step in this, and this is not about academic, it's about meeting the requirements within your own guidance that says, find the true maximum. So redoing the model to add the specificity there to say, what is the impact of the meteorological data and what happens with the spacing along the way, falls squarely within the idea of your guidance that says, tell me what the true maximum is.
Now, isn't there a difference? I mean, isn't the true maximum a term of art? Is the true maximum, in your view, the exact same thing as the best possible available data? I mean, isn't there a difference? In other words, the goal of an academic and the goal of research is respectable, but it is different than it is for a regulatory agency, is it not?
The goal of the regulatory agency is to determine if the permit conditions will provide a scenario where there is going to be an exceedance of the standards. I believe what we're demonstrating is that you already admitted, the department admitted in its review, there were exceedances next door. What we're saying is the analysis didn't focus broadly enough to consider all the inputs. It limited the analysis, which doesn't get to the question of the guidance to say, is this permit going to exceed the standard? And the short answer we find is, yes, it exceeds it. It exceeds it next door, and it also exceeds it in an area where the public could be exposed.
Thank you. And in your conversation with Ms. Locke a few seconds ago, if I'm understanding it correctly, you said that the department used an approved model. Is that correct?
The air mod.
I'm not saying I'm not talking about the implementation of the model. I'm not saying that they perfectly used it, but you said they used an approved model. Just the model itself, not the implementation, not whether or not they used this or that or left something out, just that they used an approved model. Is that correct?
What I said was, what I meant to say was that they used AirMod, which is an approved model by EPA and by their own regulations.
Okay, excellent. Thank you. And then, so now you also indicated that you had changed the model, that you didn't actually rerun the model that was done in this case, but that you changed the meteorological data. Is that correct?
So I did not change the input values. I didn't change the emission rates or the times of the emissions. That was held constant. The only thing that I did was say, run the model for all of these years of MET data. So the source term, the number one impact on what goes out of this model was not changed. Neither was the operational time, neither was the location of all the equipment out in the facility. I took on face value that the source terms that were calculated were presented correctly and ran with that.
So you made zero change. Are you testifying here under oath that you made no changes?
I made no changes to the source terms, which are an important consideration.
Okay, I understand.
I added the layer of the MET data to fill out the idea of what was going on.
I see. So you did change it.
Well, I changed it by adding the MET data that should have been included to begin with.
Yes, I see. So you changed it to add the MET data. Is that correct?
Correct, to give a fuller analysis of the impacts.
Okay, thank you so much. So am I understanding correctly that really the only outstanding issue that's on the table, I think this is important for the board members to understand, and it certainly would make everyone's job a lot easier. The actual only issue of contention that you have is that the MET data was inadequate.
No, I have two issues.
Two issues.
Number one, the background data, which is represented in the guidance, is old and out of date and doesn't accurately represent the conditions of today, of Santa Fe today, and that the permit conditions assumed that there would be a constant value of particulate matter in the background. And they added that to the source output to say, we won't exceed the NAAQS. And the reality of it is the data as it was presented by the department is subject to some scrutiny. That it was a limited data set, that the year prior, 2013, was much higher. So if we just used the data from 2013 instead of the adjusted data that is presented in the guidance, you would see that starting with the modeling output from the applicant and the analysis done by Mr. Peters, you'd exceed the next. So there'd be a violation there. And this is not theoretical data. It's not projecting data in the future. It's just the data of what the department collected in 2013. So the department went through and they adjusted their background value and they came up with their weighted averages along the way. So that's issue number one. Issue number two is that there were 4 years of Met data that were readily available and that the department made a decision to limit the modeling to only 1 year. That doesn't meet the requirements in their own guidance, and it doesn't meet the requirements or the spirit of Chapter W or I'm sorry, I get that mixed up, Appendix W from EPA when you're doing this modeling guidance. So in effect, what was allowed limited the possibility that there would be an exceedance.
Thank you, Dr. Clark. I think you clarifying these issues, makes all of our jobs a lot easier. Thank you so much. I have no further questions.
You're welcome. Thank you.
Okay, that concludes Dr. Clark's rebuttal testimony. Thank you, Dr. Clark. And we'll move to the rebuttal testimony of.
Thank you very much, Board. I appreciate the opportunity to address you. Thank you.
Mr. Jantz, are you?
Yes, Mr. Hearing Officer. Should we clarify for the record that Dr. Sahu is still under oath?
Yes, thank you for that. Just a reminder, Dr. Sahu, you are under oath.
Yes, thank you.
For prior testimony.
So good afternoon, Dr. Sahu. Good to see you again. I hope your trip is going well. I want to ask you a few questions about some of the testimony that, and thank you, Ms. Jones, for giving me share privileges. I want to ask you a few areas of questions about some of the testimony that came up yesterday. And so I'd like to start with, let's see here. This graphic, and this is from the record, the administrative record. It's Bates number 001432, and it's PDF page number 1459. This is the process flow diagram for HMA2. And I wanted to ask you this, Dr. Sahu. Yesterday, NMED claimed several times that the AP42 emission factors are the only data that are available about AAM's emissions, associated asphalt emissions. Do you agree with that statement? And before you start your answer, Dr. Sahu, I brought this graphic up to sort of give the board a sense of what the hot mix asphalt looks like. And these are pretty standard configurations, are they not, Dr. Sahu?
Yes, I think this one pretty standard. It just shows the different component parts, and those capital letter designations are the way that those sources or activities have been represented in the application and in the permit.
Okay, so the next figure I want to show you is from NMED's Exhibit 29, which is the hot mix asphalt plant emissions assessment report. And I want to go to this process diagram. In your opinion, is this comparable to the HMA2 process diagram that I just showed you?
Yeah, there are different types of diagrams. They're describing essentially the similar process. The they are of course similar. The differences being the one we saw before is in fact the plant 2 that is currently at a different location that will be moved over to where plant 5 is. This
Okay.
is a more generic, asphalt making, if you will, process where it shows the different pieces of equipment or the different inputs and all of that stuff with the hot mix asphalt is ultimately coming out at the bottom left in the truck loadout. And this is to describe, again, a more generic plant. And it's not a block flow. This is more of a schematic where the material is moving through the system and what's happening to it.
Okay, and Dr. Sahu, I'd like you to point out on this or help us walk us through using this graphic where the places are well, let me ask you the first question, my initial question again. Do you agree that AP42 emissions factor is the only available data about AAM's emissions?
No, AP42 and which is the vast majority of the data that has been used, and some smaller things which are still part of AP42 for tanks were used. As I provided testimony, and which is true and has been true for the longest time, is you prefer to use site-specific data. That's always the best source of your emissions. And because these were existing sources that are being consolidated, plant 2 is an existing source, the screening plant, the scalping plant, they're existing sources. They're all going to be sought to be bought over to plant 5. The data from those existing sources, including plant 5, which is not even moving in the same place, would have been better to use. And that data was not used. AP42 was used instead.
And in this graphic, the ducted emissions are essentially tubes where emissions come out. Is that right, Dr. Sahu?
Yeah, ducted emissions are things that are captured and that are basically exhaust gases that are flowing through ducts, and they are more point sources. You can see one to the very top right there, exactly, exhausted to the atmosphere after like a bag house there. So that's
Okay.
like a stack source.
And can emissions data be gathered from those point sources?
Yes, they can.
Okay,
You
so
can do
there's one
stack testing.
here.
Yeah, you can do stack testing.
And this is another one. Stack test could be done here.
Yeah, anytime there's a bag house or a collector or a control system, you could do stack testing, sure.
Okay, so there are at least 1, 2, 3, 4, 5, 6.
Well, the other way to look at it is in the previous, if you can take me to the previous one in plant 2, the schematic, that might be even better because it's that one. Yes, you notice that there is a stack, right? Plant bag house stack. No, just the word stack right there. So that's a stack that is for plant 2 that is essentially the exhaust of the bag house that is written above that P2HMASTK. And so that's a stack source. Similarly, the asphalt heater has another stack. Then there is a drum dryer that's also going to the same HMASTK stack. So there are a couple of stacks here in the existing plant too that could have been tested, of course.
Okay, but were any data in your review of the record provided from any of these stacks?
No, I think that was asked that question by one of the board members as to whether, in fact, the application included actual test data or tested data from the existing plants, and my answer was no. The applications used AP42, the department accepted AP42, and so there is no data from these existing plants that are going to be consolidated.
Even though they could have been tested?
Yes.
Okay. Just out of curiosity, there seem like, based on this schematic and this schematic, quite a few places where emissions come out. And there were also
there are fugitive sources. I'm sorry, there
were also fugitive sources where there were emissions. And I'm just curious, because there's such a large number of sources, does the large number of sources mitigate or compensate for the uncertainty in AP 42. So in other words, AP 42 emissions factors are averages. So we'll assume half of the modeled sources or sources to which factors were assigned are above the factor, half or below, right? But there's so many, if you average them all out, doesn't it all come out in the wash?
No, that's not how it works. I mean, of course, you have to look at each one. And when you're doing the potential to emit, you're not looking at averages and hoping for that wash. As I think Department's counsel was just telling Dr. Clark, I mean, these are the regulatory requirement here is to look at potential sources. And that's what's in the permit, potential emission rates. And so you are looking for that maximum emission rate. And you're looking at that from each source, whether it's a stack source or a fugitive source. And so it has really there's no role for averages in estimating potential emission rates.
Okay. So the next question I want to ask you has to do with the AP 42 enforcement alert, which we talked a lot about yesterday and you mentioned in your direct exam. NMED asserts that enforcement alert came out in November of 2020 and is therefore, it's new, and therefore NMED couldn't have known about the AP 42 factors unreliability. Is that an accurate assessment, Dr. Sahu?
No, for a few reasons. First of all, it came out in November 2019. I just want to set the record straight, not November of 2020. So it happened, as I mentioned, just about the tail end of the Trump administration, that EPA put that out. And the other reason why that is not accurate to say that the department could not have known is that when you look at the alert, it quotes from and it reiterates, frankly, information that has been available in AP 42's, introductory chapter from 1995. So it is essentially reasserting and reminding and alerting people that the 1995 information is still out there. And that information is in the introduction chapter of AP 42.
And this is the introduction chapter.
Yeah, it's a 10-page introduction chapter. I think there's a date stamp at the bottom right of each page. I think that shows 1995, January, I believe.
January 95.
Yeah, correct. And if you look at the alert and you look at some of the things here, the alert picks up from here that the fact that these are average factors and so on. The ratings that the alert discusses, all of that is really taken from this document.
Okay. So I want to go back to NMED Exhibit 29, where you've highlighted some text. And again, this is the department's exhibit. This is the HMA emissions analysis. Can you read that highlighted?
Yeah, I'll do that. I just want to provide one context so the board understands.
Certainly.
This document is really a portion of a bigger report, which is on EPA's website and has been for many years, almost 20 years. It's essentially a background document for a section of AP 42, section 11.1 of AP 42, which deals with hot mix asphalt plant. This document was put together in 2000. And a few years after that, in 2004, EPA put out the updated 11.1 AP 42. So this document has been around for about 20 years, a little over that. And the 2004 AP 42 section 11.1 has been around for about 17 years. In other words, everything that went in is discussed here really fed into that AP 42 section. And it is that AP 42 section with those D&E rated factors that have been used in the application. So this is not like a separate document that is somehow different from AP 42. It really supports that AP 42 document, including all the poorly rated factors that have been used in this application. The reason I think this is important is I thought the department may have asserted that somehow this document provides support for the idea that using AP42 is appropriate for estimating potential emission rates. And that is simply not true. And that's what this highlight is it says clearly these emission factors were then grouped by source, by pollutant, by control device, and an average emission factor was calculated. So I want to stress that average, because you cannot really estimate maximum emissions or potential emission rates when you use average emission factors. And so this document does not provide any support for the proposition that somehow using these emission factors that are here or in AP42, which are average factors, are somehow going to give you these maximum or potential emission rates.
Okay. And so let's go to this highlighted portion. And again, this, let me see if I can.
Yeah, there's a portion highlighted, but it says the same thing. In other words, really every instance.
Sorry, Dr. Sahi, I've got a little
That's okay. Yeah,
technical issue here. Okay.
Yeah, again, it's another instance where the document makes clear that whatever the data analysis was that EPA did in 2000 to support their AP42 section update, again, average emission factor was calculated. So there are several instances, not just one instance in this document where it's clear that they were estimating averages and not maximums.
And same thing with this highlighted portion. Yes, Dr. Sahi?
It is. In addition, where there were data from multiple tests on the same specific emission source, the test specific emission factors were averaged to yield a source specific emission factor.
Okay. So the next document I want to draw your attention to, Dr. Sahu, is, and hold on just a second. I need to reshare that so I can. Okay. What we're looking at now, Dr. Sahu, is Community Exhibit 24, Community EIB Exhibit 24, Emissions Factors Uncertainty Assessment. You're familiar with this document, Dr. Sahu?
I am familiar with this document. And again, this was now about 7 years after that first document we just saw, and about 4 or 5 years after, the asphalt plant emission factor had been updated.
Okay. So I'm going to go to a highlighted portion here, Dr. Sahu, and ask you to, well, first of all, I want to note the fact that this is peer reviewed. And can you tell me what that means in this context, Dr. Sahu?
Yeah, what EPA does is when they put out technical reports, sometimes they go to outside peer reviewers, although they're not publishing this like in the literature, but they still have a peer review process where they go to other folks and, much like you would get peer review in a technical publication, they get their comments and they address the comments of their reviewers. And this is simply saying that that was done, and they note the couple of folks that they went to get their comments.
Okay, thank you, Dr. Sahu. So let's take a look at the next highlighted portion. In this executive summary, this first highlighted portion is to assess the uncertainty of the best rated emissions factors. Those are A and B, right?
Yeah, and again, just I want to make sure the board is understanding. What EPA did is they, in this exercise, were really looking, as they say so later on here in some of the other highlights, is they were aware that people were using these average factors for things inappropriately, and EPA wanted to know what does their data in AP42 say about the maximum or the higher data compared to the averages for a given set of pollutant data. In other words, they wanted to know what would be the uncertainty, what would be the difference if you used the maximums of the underlying data that were used to calculate averages that are reported in AP42, And all that first sentence says to limit their work, they only did that analysis for the best rated emission factors. And we'll see here that they only really focused on, for the most part, on the A-rated factors, with I think a single B-rated factor.
Okay. And again, there's the admonition to be cautious in the context of individual permits. Is that correct, Dr. Sahu?
Yes, this is exactly what EPA has said in 1995, that introduction, that emission factors are expressed as an average. That's that first sentence. Emission factors are intended for estimating emissions for a large number of sources, like an inventory for the nation. And then they recognize that people use these emission factors from AP42 beyond their original purpose, including this permit, individual permit kind of estimates of emissions or rule applicability. And then they recognize that this is beyond, this is expanded beyond the original purpose for what these factors were designed for. The points I was making in my direct testimony. And then therefore, then they lead on to say, what is the uncertainty if you now start doing that and applying these in individual cases? And they, again, limit their analysis to just the best rated factor and what that uncertainty would be. That's correct.
Okay. So let's get to the punchline here, Dr. Sahu. This chart at the end of the executive summary, can you explain this to the board?
Yeah. Actually, if you just go up a little bit more on the table, I just want to, at the risk of maybe getting a little wonky here, I just want to discuss that one thing on the left where what they're, because that's what they're talking about in that chart. The chart represents something called an uncertainty ratio. And that's defined in that first little equation, which is a ratio of two things. On the numerator, you have something called a target statistic, and divided by the emission factor, which we'll see later on is just the AP42 emission factor. In other words, they're dividing two numbers, one to the other, and showing the results of the uncertainty as a ratio. The target statistic is defined right below. It is basically looking at the 95th percentile of the underlying population of data. If you recall in my direct testimony, I said that emission data are not identical. I mean, even if you do a stack test, you do it 3-4 times, you will get different data. So you have a population of data, you kind of a distribution, kind of a bell-shaped distribution, if you will. And what they've picked is the 95th percentile, not the very maximum, but the 95th percentile, saying that could be a surrogate for potential emissions or potential emission rates. So let's look at the ratio of that 95th percentile to the average, meaning what's in the denominator is the average. As you can see here, the emission factor in the denominator is the AP42 factor. So they looked at the sort of where the AP42 factor came from. They looked at a bunch of A-rated factors and one B-rated factor for each of those. They went and looked at what was all the data that went into calculating the average. And then for each of those, they looked at this 95th percentile, the statistic, and they computed the ratio. And what you'll see in the table that you were highlighting is that ratio shown for a few different scenarios. So now that, I'm sorry I had to do that so you'd understand that what is being presented, the numbers are that ratio. And I can show you just as an example, take particulate matter, although they did this analysis for the HAPs, hazardous air pollutants, and several different types of PM, and also things like NOx and SO2. And by the way, just to the left of the table, it just confirms what I was just saying. It says, we analyzed the data for 43 A-rated and 1 B-rated AP42 emission factor, if you can see that. It's not highlighted, but just immediately to the left of the, that's right, 43 A-rated and 1 B-rated. So mostly A-rated factors. Now coming back to the ratios, you see the ratio even for PM, and they have two columns. One is where there were only 3 data points available to make that average, and one is when there were more than 3. There were more than 25 data points available. So they were looking at, sort of when there was a lot of data available, more than 25 data points, a good filling in of the distribution, and then one where there were just 3 data points. And that should tell you something right there, that even for A-rated factors, there are many cases where you just have three numbers, where that number is coming from in AP42. And the ratios are telling. That means the ratio of the 95th percentile to the average is, you can see it's ranges all the way from 2.2, which is the smallest number in this table, all the way to 13 times. So even in the best case, A-rated factors, the 95th percentile, which should be used or could be used to estimate these potential emission rates, is 220 times, 220% of the AP42 average. That's what 2.2 means. And it could be as high if you're calculating some hazardous air pollutants to 13 times, which is 1300%. So, and I think I tried to summarize that very quickly in my direct testimony 2 days ago, but this tells you that you can make huge errors in your potential emission estimates, huge underestimations, not just errors. When you're trying to pass off an average as an input into a calculation of potential emission, 2.7 times, 2.7 times, 3.9 times, and you can see the numbers, and these are for the A-rated factors. And although EPA didn't do this for the D and E-rated factors, those would be even worse than these ratios. And these are already pretty significant errors. That's the point.
Thank you, Dr. Sahu. So one other thing. Let's see. Okay, so it says that this study does not attempt to provide guidance on the application of admission factor uncertainty in making environmental decisions.
Right.
Do you see that?
Yeah, this is just a statistical analysis. This is not telling people how to use AP42 or what, because there are many different applications of this data. They're simply saying they're not providing that guidance. They're simply pointing out that this distribution's upper end is so many more times higher than the average. And so if you, for example, a guidance would not be appropriate because if you are going to use it in permitting and if your goal is to estimate potential emissions, you can draw your conclusions from that. You can say your potential emissions are many times the average AP42 emission factor. You can then account for that in your permitting action.
So I guess my follow-up question then, and you I think alluded to this in your answer, the fact that it's not intended to be guidance, does that necessarily mean that this should be disregarded, that agencies should disregard this?
No, of course not. I mean, this is simply analyzing the data that is in AP42. In fact, they're going and being helpful and saying, if you don't have the time to look under the hood of AP42, we've done this for you for the A-rated factors. And we are telling you that if your goal is to do something like a 95th percentile or an upper end value, which you would want to do for potential, then you have these very high ratios. So they have done the statistical analysis, so you don't have to do that. That's really what this is intended to do.
Okay, thank you, Dr. Sahu. So the third area of questioning I want to get to, the third and final area of questioning is related to the permit, and this is Community EIB Exhibit 25. NMED, excuse me, asserted that permit conditions taken as a whole assure compliance, in part because certain permit conditions refer to federal regulations. Do you agree that the permit conditions in the permit 8585 assure compliance with the NAAQS?
No, I do not. And I've spent quite a bit of time looking very carefully at the permit. I will say this, the permit, of course, doesn't contain the AP42 calculations and the details, and the numbers that are there summarized rely on AP42. So everything I've said about AP42 underestimating these emissions of potential are really at the heart of why no way you're going to assure compliance with the NAAQS. Again, please, to keep the big picture in mind, this permit is issued under the idea that the NACs are being met, and as we've seen, the NACs are barely being met under the calculations and the review that has been done by NMED. I don't want to repeat that for PM. You've heard there between 97% or 99%, depending on the averaging time and so on. So it doesn't do that, but it further points to several reasons why the permit conditions are not appropriate. And I think it'll be good to touch on a few of those here so the board has a good understanding of what is required under the permit condition.
Okay. So let's start with this regulated resources risk. You highlighted the manufacturer date. Why
if you go back a little further, the reason I highlighted the manufacturer is I make the point that the purpose of the permit, I thought there was some confusion because, and maybe relating to this, yes, let's go back right there, is the fact that it is truly a consolidation. I thought there was some confusion that you could not get test data from these existing sources because something would change as they're being moved. And I didn't find any evidence of that. Very little of it is intended to be changed as far as I can see, and I'll point that out. It is truly going to be, as the item number C says there, it is just moving, physically moving, and then putting it all together. These two plants that are not there, and of course plant 5 is not moving, it's still there, and nothing is happening to that. The other highlights in the table is to make it clear that we are in fact talking about potential. And potential is never average. If you use averages, you don't capture the maximum. So, and that is a point worth stressing because there's lots of, regulatory this and academic that I've heard even today listening in. But arithmetic is arithmetic. You cannot pass off an average as being the same as a maximum, or an average the same as being the 95th percentile. I mean, that's just wrong, and it is never true unless every number in the distribution is the same, which is a trivial thing that never happens. So anytime you have a distribution of numbers, the average will always be lower. And if you're going to use that, feed that into your calculation, you will always underestimate. And because you have so little room in your NACs compliance, any degree of underestimation of your emissions means you're going to blow the NACs, be higher than the NACs. And so, and my criticism about regulatory malpractice, about all that stuff that we went on last time was in this particular permit, in this instance, it's not generalizing, not happening in some other state, not happening in other NMED decisions. In this instance, by using averages and barely showing compliance with the NACs, leaves you no wiggle room at all. Your average is not the right metric. If something else is a better metric and should be the 95th percentile, the maximum, because you're doing potential emission rates. That's the whole point here. That is that entire arc. What emissions did you feed in to calculate your concentrations from your air mod model, and then say you're meeting the NACs? And even though it says potential emission rate, what's under the hood is using average emission factors. And beyond that, very poorly rated factors. So stressing that, then we can go to, I think, the highlight you had. And then that's true for all the tables, by the way. The next table, 1 or 2B, is also potential emission rate, but I didn't highlight.
Okay, and so these are just for different pollutants, yes?
Yes.
Okay.
So now I can explain the dates. That idea that you're moving and not changing anything shows the manufacturer date is, in fact, for plant 2 is 1962. I mean, this plant began in the Kennedy administration, and that plant with 1962 equipment is going to move. That's what it confirms. So there's no changes that, as far as I could see, that the applicant has said they intend to do to plant 2. Let's
okay.
Or 1973, one piece of equipment was changed. And then plant 5, of course, is staying the same. And then the crushing screening plant, which is moving, is highlight below, is mostly 2001. So again, that's 20 years old, thereabouts. Go over to the next page. And then there are a few that say unknown. They're being shop built. I think some conveyors are being maybe rebuilt or being built new for this move. But the vast majority of the equipment coming is the older equipment, which is existing. I just wanted to show that this is truly a consolidation. This is
Thank you, Dr.
those plants
Sahus.
exist
Yeah.
and the stacks exist. This one in the permit is worth noting. We were just looking at that little block diagram. It shows that, first of all, if you go to the top of the table, it shows this is in the permit. It shows that these are the control equipment. That's the section of the permit for the entire facility, everything. And it is, we focused on PM, and frankly, PM is the only pollutant that's being controlled. You look at PM10, PM2.5, there is no controls proposed whatsoever for any of the other pollutants. NOx, SO2, CO, nothing else is controlled at all. And what I've highlighted here is within PM, there are just the 3 bag houses. There is a silo bag house, which controls both plant 2 and plant 5 filling emissions. And then there are separate bag houses for plant 2 and plant 5 for the asphalt mixer bag house. Because we'll talk about them in a minute for permit conditions. The C8 and C9 are the individual bag houses for each of plant 2 and plant 5. And then the C7 is the combined filler bag house. Okay, that's just more, so we start using these terms next. This one is the allowable emissions. Again, basically, this is your, it says allowable here. You compare the numbers. This is basically your potential emission rate that was summarized above. I'm showing here that your, gaseous emissions are not coming from many sources. They're basically all PM emissions. You look at the last 4 columns, there are allowable hourly emissions, and then annual tons per year emissions for PM10 and PM2.5. I've highlighted the ones that are coming from those bag houses, that P2HMA fill and the P2HMA stack. Those are the stack sources. The other ones are fugitives. That's just to, because the stack sources certainly can be tested. You can test the fugitive ones also, but it's a little more work. Let's keep going.
Okay.
And the same exact thing for plant 5. It has mostly the same 2 parallel sort of stack sources and then sources. And then the crushing screening plant, let's pause there. There's no stack sources, really. All of them are fugitive sources. This is the plant that's being moved, the CSS plants, the crushing, screening, and scalping plants. But I want to, maybe we'll come back to this table, but there are permit conditions that basically say all these rates in this table have to be met. And they have to be met, of course, at all times. This is continuous compliance. And I want to tie the permit condition requirement to these numbers, and especially for the crushing screening plant, which we'll see in a minute. Okay. So they have all these numbers for each source within that, with the hourly rate and the annual tons per year for PM2.5 and PM10, and they are all listed on this table, and I'll make reference to that in a second.
Okay.
So I'm not highlighting a whole bunch of other things here, but let's go to. Let's skip this one. This is another example of opacity. If we have time, we'll come back to that.
Okay.
But we'll go directly to the crushing screening plant. And this is another opacity for the engines. There we go. Let's go back. Yes. So this is now the crushing screening plant, and it is a portion of that plant, and it covers a whole range of those individual sources. And first of all, the requirement is very important, and I want to just highlight the part that is highlighted under 1. It says that all those conveyor transfer point units, and there's a whole list of them that I'm not going to read out, and those were in the table. It says that shall have a wet dust suppression system. In a wet dust suppression system, you're basically squirting water in case you have some emissions that you can see. And then the goal of that, and this is where it becomes, in my mind, unenforceable as written, is the goal of that is to minimize fugitive emissions. First of all, it's minimize. Minimize might mean different things to different people. It's not enforceable when you use terms like minimize. But beyond that, it says to minimize emissions to the atmosphere and to meet the emission limitations contained in this permit. And that is that latter part that makes it completely unenforceable. when it says to meet the emission limitations contained in this permit. And those only emission limitations in this permit are in that table that I was showing you, where there was row after row of numbers for this crushing screening plant for every single point. It had hourly and annual emission limitations. And there is no connecting of the dots. There is no testing requirement. There is really nothing other than qualitative. And yet you're supposed to show you're going to meet those emission limits that are in this permit. I don't see how that can be done. If you look at carefully, all you're doing here is based on your observation each day. And I've highlighted that by visually inspecting these different units, make sure that they seem to be in working order. And you will use this dust suppression system. And somehow you will be able to meet those emission limitations. So this is an example of something that is clearly not enforceable. The inspector can't go out there and look at the dust suppression system, even if it is working, and make any judgments about whether a particular drop point has a 0.009 pounds per hour or whatever the number is in the table, and say, yes, I can see how that number is being met. It's simply not possible. So that was the point of showing that this is an example of an unenforceable permit condition.
Okay. And would you like me to go back to the?
No, I think I'd like to assert that if people have the time to go back, they will see that there are emission limitations for every single point. This particular condition references that, and there's no way to connect it to. This next one says that you shall develop a fugitive dust control plan. I'm just highlighting that to show that I haven't seen it. It's not in the record. This is a future plan as to what it will or will not do. There's really no idea. One cannot guess what might come out of this requirement, and it's certainly outside of this record right now.
And Dr. Sahu, are you aware of any opportunity for the public or impacted communities to weigh in on this fugitive dust control plan?
I did not see any condition that it will be put out for public comment, like this permit was put out for public comment. So I didn't seem to be. I think this might be just a plan that is developed by the applicant and just provided to the NMED, and then it goes from there.
Okay.
And so here again, I'm just pointing out that terms like to minimize, and those are really not enforceable terms. And then secondly, the monitoring here is once a calendar month, somebody's supposed to inspect each area, which is not really defined what area means, that no fugitive dust is being minimized. And then if you need to update this plan, of course, once a month, at the time that you are doing an inspection, it doesn't say under what conditions, or if you're doing the inspection the day right after it rained or snowed, or it was a dry day and had been dry for 15 days before that. It leaves a lot as to how representative these inspections will be, setting aside that they're still pretty infrequent. That was, just wanted to point that out. I don't think I highlighted, because of, in the interest of time, all the generator and engine things that are coming up. So I think we'll go to the asphalt plants next. Plant 2 or plant 5 is coming up. Or maybe this one. There is a
So this is one of the parts of the federal rules that the Environment Department suggests will assure compliance with NACs and emissions limits. Do you agree that
No.
that's what this does?
No, that's a misreading of, this is a new source performance standard. First of all, it applies to a subset of these units. This doesn't apply to all the units in the crushing plant. It only lists the ones that are listed there. And because this new source performance standard only applies to certain types of operations and so on that are spelled out in that portion of the regulations. So only for that subset that is enumerated here, there's a requirement, and the requirement goes right below the, where I can see it is basically some opacity limits. And it is not in the form in this NSPS about any emission rates or any concentration limits. My fault. It simply is opacity. As you can see, 7% opacity, 12% opacity, and later on some 10% and 15% opacity. It does not say anything about emission rates. And of course, therefore, you cannot, and this permit in the entire record, frankly, has nothing about how a certain level of opacity is related to a certain level of emissions of PM 2.5 or PM 10. In other words, there's no correlation. There's no equation that says if I have 7% opacity, I'm getting so many pounds an hour of PM, or if I have 12% opacity, I have so many pounds of PM, which you can then use maybe with modeling to look at your NACs if you needed to do that, but it doesn't have that. So just by even being compliant with this NSPS, it is a separate regulation. It doesn't guarantee that you're complying with NACs. NSPS requirements have to be met in their own right, and the NACs requirement has to be met in its own right. One doesn't tie with, they're just separate requirements.
Okay. So going down to the monitoring initial compliance test.
Yeah, and again here, well, the NSPS requires you do an initial compliance test. All you're doing is doing an opacity measurement, really, and you're going to use one or two opacity test methods. I think if you go over to the next page, you'll see method 9 or method 22 are listed as the test methods on the next page. Yeah, it says method 9 and method 22. And you'll do that initially. And then the periodic compliance test is you have to come back once per month. It says at least once per month, do a method 9. And that involves doing a test, basically looking at opacity over 6 minutes. So NSPS for these select subset of sources simply says come back and look at it for 6 minutes, take a method 9 reading. A method 9 is where there's a trained observer who has to be in the right position in relation to the source and the sun, and they will look at make sure that you're below the 7% and 12% requirements, and then you'll come back next month at some point and do it again. Obviously, that is very infrequent. I mean, those 6 minutes you may be fine, you may have a lot more opacity later on. The NSPS by itself, of course, is not guaranteeing continuous compliance. It just says you have to do a spot check. So that was the point, that it is a very, very minimal requirement done 12 times a year.
Mm-hmm.
Out of the 6 minutes time, the 12 times a year, a little over an hour, hour and 12 minutes, hour and whatever minutes you've gone and done that spot check, basically.
Okay. What's the significance of if requested by the department in writing?
I highlighted that because the department does have the ability to require more frequent tests. I don't know that has something that has been discussed. There's nothing in the record to indicate that will be done. But even if they do that, it's just additional method 9 readings each time to do another 6-minute reading. So it's still going to be very spotty.
So would 2 hours per year make a difference?
2 hours per year does not make a difference, of course. But okay. The nature of these NSPS, regulations was not to certainly show NACs compliance.
Okay.
I think now we get into the asphalt plants. This is section A400. The initial few things pertain to this production and temperatures of these silos. So these were the stacks that I had pointed out. These are the C8 and C9s. These are the main stacks, one for each plant. Plant 2 is the C8 bag house and the stack. Plant 5 is the C9 bag house and the stack. So I wanted to look at these requirements, and I think there's some conceptual problems, and I want to highlight one of them.
Okay.
So these are bag houses, and so one of the requirements is you have this pressure gauge. I think that has come up a few times before. You're measuring this pressure drop across the bag house, and what a bag house does is it basically is a filter. It's got a lot of fabric bags. The gas with dust in it hits the filters, that like any filter, it will stop the dust and it will let the gases pass through, and that's what's coming out of the stack. But when it stops the dust, the pressure, the dust layer becomes bigger and bigger and bigger, thicker, and it starts to form a barrier to the gas flow. It impedes the gas flow. We call that increased pressure drop. That means the gas has to be pushed against this resistance of this thicker and growing dust layer. and only then it can pass through the filters to go to the stack. And that is measured through a pressure gauge. Basically, it can tell you what that pressure drop is. The way this is written is you're going to monitor this pressure drop, and then you're going to draw some inferences from it. Just a little bit below, you want to stay. It says what I've highlighted. You have to stay within 15% of the pressure drop recorded in the initial compliance test. So the idea is there will be an initial compliance test for each baghouse. You're going to record what was that pressure drop. And then this says that you will have to take some action if you are not within 15% of that, whatever you recorded in that initial test. Well, the difficulty I'm having is this. The pressure drop across a normally operating baghouse does not stay the same. When you build dust along the baghouse, as invariably happens, imagine you start from a clean baghouse, it has no dust on it. You start your process, it starts increasing the dust going to the baghouse, the pressure drop starts to increase. That's how the device operates. And then it keeps increasing until a point it's a preset point where it says, you know what, that's enough. I'm not going to allow any more pressure drop. You need to clean the bags. You need to remove the dust from the bags. And that, depending on the baghouse design, you wrap it, you shake it, you blow some air in reverse from it, you pulse it. There are different designs, and you shake the dust off. The dust then is collected and sent off somewhere else. And then the pressure again is reduced, so more dust can be accumulated. So it's a cyclic process. There's like a sawtooth. The pressure starts low, it increases, and then you clean it, the pressure drops, and again, the cycle begins. So the pressure is always changing across the baghouse. Yet, the way it's written, there is no reference to either an initial pressure measurement, the end of the cycle pressure measurement. And so without that, this is almost written as though the pressure drop will be somehow same or dialed in like the initial performance test, and you're going to make some judgments as to whether it is more or less than that pressure and within 15%. But that is not how baghouses operate. I'm sorry to say that, but baghouses operate with changing pressure, and that's just the nature of how they're designed to operate. So it's a conceptual problem that I don't know how one is going to show compliance with this kind of a condition.
Okay. So I'll move down.
And this is, again, I was talking about, there's a monitoring, there's a monthly monitoring, just physical inspection. But really there is no other monitoring of the emissions or anything like that.
Okay. All right, here we are at the initial compliance test. You've highlighted this, Dr. Sahu.
I want to show that this was that initial compliance test I was talking about. It does measure that PM 2.5 NOx and CO at each of those two stacks. And presumably it's going to measure some other things that we'll see later on, because there's an NSPS that applies to it. Mention of it here. But then it says that monitoring there, that you will measure that baghouse pressure drop. That's the one that is related to what I was saying below, because that pressure drop will always be changing. And that snapshot during the compliance test doesn't mean that the baghouse pressure drop is dialed in and is constant. So this reflects the same confusion with pressure drop measurements with baghouses.
One thing I want to ask you about this, the initial compliance test requires stack testing. Is that your understanding?
Yes, it requires stack testing for those pollutants, the PM 2.5 and CO, correct.
And do you find a requirement for periodic stack testing anywhere else in this permit?
Well, there's no periodic required stack test, just this initial stack test. There is no periodic requirement for these two. It's not listed anywhere. There's just the one-time stack test. That's it. Okay. And then you measure supposedly this pressure drop across the baghouse, which really, as I've said, it doesn't make any sense. And so then there's this NSPS that also applies, much like to the crushing plant that has its own NSPS. There is another new source performance standard that applies to this asphalt plant stacks, these plant 2 and plant 5 stacks, and that is subpart I. And this one, actually, the requirement is a little different. The requirement is there's a grain load, what we call a grain loading standard. It's that 0.04 grains. Grain is another unit of mass, basically, the 7,000 grains to a pound. So it's a grain loading, so many grains per dry standard cubic feet of the gas coming out. and an opacity measurement. But I didn't see in that initial compliance test where the grain loading is also supposed to be measured. I presume that will be, but it's not listed in the initial compliance. But let's go to the monitoring there. And the monitoring only talks about the opacity portion of it, the method 9 opacity, but doesn't talk about the grain loading.
And it says that it should be done the opacity test should be done according to the requirements 40 CFR 60 subpart I and appendix A.
Yeah.
What's the significance of that, if any, Dr. Sahu?
Well, the 40 CFR subpart 60 is the NSPS general subpart, and subpart I is the specific subpart that we're talking about. And appendix A is a general subpart that has the various methods. For example, if you need to know how method 9 works, it lays out all the requirements for method 9 in appendix A to 40 CFR part 60. It just tells you how to implement the method.
Okay, and is that where method 5 is located?
All the EPA test methods are in appendix A to sub 40 CFR 60. Method 5 for measuring particulate matter, filterable particulate matter, method 9 for measuring opacity, and a whole bunch of other methods. They just listed in appendix A.
Okay, and I want to talk a little bit about that. I don't mean to derail this, but yesterday we talked a little bit about EPA method 5, and that outlines a process for stack testing. Is that right?
Stack testing to measure particulate matter, right?
Okay. Does method 5 contain any schedule for stack testing?
No. None of these methods, they just describe the method. None of them tell you how often to do it or how often it should be done. Those are permit conditions. They're separate. They only tell you how the method is done. It's the how to do the method, not how often to do the method or when to do the method.
Okay, so other than this initial compliance test, method A wouldn't require that the operator do stack tests on a regular basis or even at all.
No, exactly. I mean, I should leave no doubt about this whatsoever. I mean, this is just factual information. 40 CFR, any of the subparts, they don't talk about the frequency, okay? Appendix A certainly doesn't. Appendix A, where it describes the methods, doesn't really have frequency. It just lays out the method. You know, you'll have a trained observer, what it takes to get the training, how you stand in relation to the sun, where the source is, and you know how you record the data. It has all those details, but it doesn't tell you, you know, you do this once a week or once a month or once every 5 years. It doesn't tell you any of that. No.
And so it's incumbent on the regulator to put the frequency in the permit. Is that right?
Yeah, it's just like we saw in the previous conditions. If you want something done once a month, you write down once a month, as some of the other conditions do. And if you don't say anything, yeah, then the method won't tell you how often it should be.
Okay. All right. So going down to the next highlighted part, what's the significance of this highlighted area, Dr. Sahu?
And this is again the same problem with doing that pressure drop I was telling you. So this says that you shall cease operation if the pressure drop is not within the manufacturer's operating limit or the range correlating the opacity with compliance with NSPS-I. So what I didn't see here is, remember NSPS-I has an opacity limit, which is that 20%. And this one says the pressure drop of the bag house has to correlate with that. In other words, you did some testing and it shows your pressure drop was, I don't know, 3 inches of water gauge, and that you got 18% opacity. And I just described to you that in a bag house, a properly run bag house, that pressure drop will continue to increase until you clean it. Then it'll drop. Then it'll continue to increase and clean it until you drop. So I'm not sure what you're going to do to quote unquote correlate your range of pressure drop with this opacity. It's just simply not clear. And therefore, when a permit condition is not clear, it's my opinion that it's not enforceable.
Okay. All right, on to mineral filler silos and associated control devices.
It's very similar issues. This is the other bag house. The only difference is
Objection, Mr. Hearing Officer. I'm not hearing that this is rebuttal testimony to the department's testimony. What this seems to me, in some cases that it is, but what I feel like this is redirect, and we're going through the entire permit. I think that this needs to be tied to Mr. Peters or Ms. Prim's testimony. This is rebuttal testimony. This is not redirect. They've had this opportunity at the very beginning. They had this opportunity 2 days ago. And it just seems like what they're trying to do is sort of put on their case again to try and cover up things that maybe they discovered they didn't do in the first place. And so, and I think moving forward, they should tie this to the testimony, responding to the testimony that our witnesses given. That's the purpose of rebuttal.
Right. I agree with Mr. Vihill's characterization of the purpose of the rebuttal. And Ms. Prim testified that taken as a whole, the permit conditions guarantee compliance with the NAAQS and emissions limits. Dr. Sahu is going through, and she wouldn't say a specific, she wouldn't point to a specific condition. She wouldn't go through, and Mr. Vihill didn't go through with her talking about specific places. So we are forced to go through condition by condition and show how, in fact, those conditions do not guarantee either one, compliance with NAAQS, or two, compliance with emissions limits.
I believe, Ms. Prim, did you have a reply, Mr. Vihill?
Yeah, I did have a reply. She did go through the conditions. It's true she did not go through all of the conditions. So, I think that what they need to do is go back and look at the conditions that she spoke to and reply to those conditions. And the idea that what she was saying was that the department created an enforceable permit is now opens up the door to them to go through and rebut every single condition in the permit with no additional evidence. I just don't think that that's the purpose of rebuttal. It's essentially, I mean, what they're doing is putting on a direct case. They should have done this from the very beginning.
So, your Mr. Hearing Officer, in fact, Ms. Prim did talk about bag houses. She did talk about pressure drops. She did talk about opacity, and we are clarifying that those permit conditions actually don't do what she said they did.
I believe she did testify about the matters you just described, Mr. Jantz. I also think she had general testimony that the permit conditions assure compliance. And so I think this is appropriate rebuttal to that. I'm not sure we need the detail that you're going into here. I think if you could go through and point out the areas briefly that where compliance is assured with a brief explanation, that would be sufficient for purposes of the record.
Okay, we'll do our best to move it along, Mr. Hearing Officer. All right, Mr. Sahu, we're back to mineral filler silos and associated control devices.
I know this is tedious and I'll keep it very short. This is the other bag house. Very similar issues, so I won't belabor them. The same NSPS applies to them that we talked about. The only difference is this is taking gases from both plant 2 and plant 5, but same exact issues. There is a requirement for pressure drop. Same bag house will have varying pressure drops. There's a requirement to track it and be within 15%. I don't know how that is, as a practical matter, going to be done because bag houses pressure drop changes. And again, there is no correlation between the opacity and emissions and ultimately NAAQS compliance. So I'll just leave it at that because the issues are similar to the other bag house.
So this is the initial compliance test. Why is this significant?
It's the same thing, pointing out that just like the other C8 and C9, there's a requirement for initial test. And again, all you're doing is measuring the pressure drop across the bag house, same problem. And again, there is no subsequent compliance test. In other words, this is a one-time compliance.
Okay.
Test. And this is the same NSPS subpart I. It only has slightly different requirements. One being that once a month you'll do a 15-minute method 9 instead of a 6-minute method 9. That's still too little time, of course, for continuous compliance. And then the pressure drop related problems that I pointed out apply to this bag house as well. So I will not repeat that.
Okay, and we talked about the frequency there.
Sure. It's the same problem, the same compliance with the opacity limit. There's no correlation between the pressure drop and the opacity limit.
Okay.
I think that's it. I like the other ones.
Let's see. Okay, yes. Thank you, Dr. Sahu. That is all the questions I have for you.
Okay, we'll go to cross-examination from the department.
Thank you. Hello, Dr. Sahu. How are you?
Hi, Council. I'm good. Thank you.
Ms. Jones, can I have the share screen, please? Can you see that, Dr. Sahu?
Yeah, the enforcement alert's just coming up. Sure.
Okay. Not to be too persnickety, I just wanted to get you to take a look at the date of this enforcement alert. Earlier, you said it was November 2019. Can we agree that this says November 2020?
I absolutely stand corrected. It's still, I remember it as the end of the previous administration, which would have been November 2020. So you're correct.
Yes. That's all. Thank you so much.
Sure.
Okay, I want to talk a little bit about this emissions factor uncertainty assessment. And this was prepared for the EPA, correct?
Right. The EPA used a contractor, and that's how the EPA prepares its technical reports. They have an on-call contractor who they're tasked with preparing it. That's correct.
Yes. So this is an academic document that was developed by what you might call a think tank for the EPA.
No, that's not how it works. RTI International is not a think tank. EPA has, as a normal course of its business, on-call contracts that they use for all kinds of technical work, developing rule development. It's part of their regulatory work. It is not academic work. EPA is not an academic institution, but they do rely on contractors to do data analysis and all kinds of other things. RTI happens to have been the contractor who's EPA's contractor tasked with preparing this report, doing the underlying data analysis, getting it peer reviewed and all that.
Okay, and you said they're not a think tank. Can you tell us what RTI International is then?
It's basically a consulting company that bid on a contract to do this EPA support work. I mean, over the years, there have been many such contractors. I mean, EPA puts out these contracts to bid, and various folks bid on them. I mean, they are typically consulting firms that do this kind of agency support work.
I see. And what was, in your view, what is the difference between a consulting firm and a think tank?
Well, the way I think of think tanks is think tanks are they put out policy documents and they look at, maybe they want to influence government policy in a certain way. They're more driven by policy. This is just, for the most part, analytical work that the agency might say, here are 15 stack test reports, summarize them for me. Or, a particular staff who's developing rules may say, I need to collect information collection from this group of industries. So they work at EPA. They mostly are tied to the EPA's folks in the Research Triangle Park, which is their support work for the air quality work throughout the country, where rules are developed and so on. And so RTI had this contract at this time, is all I'm saying. They're not a think tank.
Thank you. But RTI is a separate entity from the EPA, correct?
They're a contractor to EPA. It's prepared for, as you can see, or for EPA by RTI.
Yes, thank you so much. Now, you said that it's not an academic document. Who do you think wrote this document? If it was not academics, who wrote it?
The RTI staff. I mean, that's how they would write it. They would write a draft. EPA staff would review it. They went out to external funding. Peer review, as was pointed out earlier. So it was prepared by that particular office. You just had it. It gives you the contract details and the peer review folks right there.
I see. And so non-academic work, is that usually sent out for peer-reviewed work? Wouldn't that seem to indicate that it's an academic work?
No, I don't know. I think you're respectfully, you're confused. I mean, EPA, that's what I mentioned. Even non-academic work, EPA reports, they do do peer review for those reports. And not that it's important, but I have been a peer reviewer on EPA reports when they want to go out in my line of expertise. So it's not academic work, as in you're doing research with students, or you're doing something at a university and you're publishing that in a technical journal. That's academic. That's your standard academic peer review process. But EPA's technical reports often get outside peer review by the agency.
And Mr. Hearing Officer, I'd like to object this line of questioning based on relevance. Whether or not this is quote unquote academic or something else, unless
I'm authenticating this document.
it's already been admitted into the record.
I'm authenticating it for the fact finders. I'm not trying to get it out of the record. It's in the record. I'm authenticating it.
I think the questioning goes to the weight that should be given to the document in considering the evidence in the case. So I'm going to allow it.
Thank you. So Dr. Sahu, earlier in your testimony, you made a point of pointing out that this was peer reviewed. Now, to my mind, the reason why this is done is to sort of tie it with reliability. And that reliability, I mean, if you think about the sort of the model that we live under, right, Western epistemological model of empiricism, that you're tying the reliability of this document to the academic peer-reviewed process. That's not what you were doing?
No, I mean, obviously the agency it does. And by the way, I just want you to, it's routine for EPA to do its, to undergo this process. They have a contractor who pulls together the report, who does the technical analysis. If the subject matter is important enough, EPA feels like they need to go out and get comments from either folks in academia, other consultants, other practitioners. They do that. That's how they've always done their work for the longest time. And so this report followed the same practice. And they went to a couple of professors in this case and told them to, because this report did a lot of statistical analysis. They just wanted to make sure that the folks at RTI did the work right, or if they could have done something differently or wrong. They got feedback from these two peer reviewers, and they're letting us know who they were.
Yeah, sure. So are you saying that the peer review process that this document underwent is substantially different than the peer review process that, say, an academic article in a peer-reviewed journal would undertake? It's a different, are you saying it's a less stringent process?
No, I'm not saying that at all. I mean, these people are independent reviewers. They bring to the peer review process as much rigor or as little rigor as you would want them to do. They use their judgment. They look at, whatever they find. There are academic peer review journals that are occasionally withdrawn, as you know. I mean, Lancet, the medical journal, might say, yeah, we're going to withdraw an article. We had a problem with peer review. Or, in other words, that process, of course, you're going to peers who are experts in their own right, and they will give you whatever they think that needs to be fixed or they like or dislike. It's a similar process. It's just that this is not a paper that's going to be submitted by EPA for publication in a technical journal. That's all. It's an EPA report. The end is the end is an EPA report and doesn't get published in a academic journal. That's all I'm saying.
I see. And all of the peer reviewers were university professors, correct?
There were two in this case, and they were both at different universities, correct?
Okay, thank you very much. Thank you. Let me see here. I don't want to waste your time. I'll have to make sure I get my my page numbers right. Go to page 45 of the uncertainty assessment here. So as you said earlier, that this document is not intended to be used to make any kind of regulatory assessments for individual facilities. Is that correct?
Right. They just took AP42. They took, as I said, those 43 different A-rated factors and 1 B-rated factors, and they just looked at this 95th percentile of the underlying data to the average. It was just that. It was these ratios they came up with. They said in the preface that one of the drivers, the motivations for doing that was the EPA had become aware that AP42 factors, which are averages, were being used in individual facilities. And therefore, they thought this would be helpful for people to know that if they did that for individual facility and used an average, there could be these big discrepancies.
Sure. And so the uncertainty that we're talking about here is a statistical uncertainty that is of a what you might call a representative population of facilities. Is that correct?
Well, no, not exactly. It's an uncertainty that is in the data that supports the average AP42 A-rated factors that were used in this analysis.
And let me know if I got this right. I'm a little out of my element here.
I just want to be sure. I just want to be sure which document we're in right now. I don't want to be.
Oh, I'm sorry. This is EIB. I apologize. EIB exhibit. EIB exhibit.
Oh yeah, the same. Okay, the 2007
AP42 uncertainty document. I'm sorry.
That 2007 document, correct? We were just talking about.
Yeah, and we're on the PDF page 46.
Yeah, I'm just looking at the screen. Okay, that's fine.
And I just, just to sort of get a sense of what this document does and what it doesn't do. So yeah. Now this document here, if I'm reading this correctly, and maybe I'm not, it looks to me like for the purposes of a drum mix, hot mix asphalt plant, which is the first type of facility there, what they did was they chose 19 facilities as a representative sample. And I'm not calling in their methodology for creating the sample. I'm just pointing out the number. Let's just assume that the number that the representative sample that they chose is sound, and I'm going to go ahead and go along with that. But the number of facilities that they chose for this particular type of plant was 19. Is that correct? Am I reading that correctly?
With one slight clarification. So what in that, if you read that first line correctly, it is for drum mix asphalt plants that were using either natural gas, number 2 fuel oil, or waste oil that had reported benzene emissions in their stack. They had 78 runs, individual test runs covering 19 tests from 19 facilities. And the average of all of that is that 0.0004 number, looking at all 78 runs from these 19 facilities. And then what these folks at RTI did is say, okay, now that we have 78 runs, we have a distribution of benzene from these 78 runs. The average happens to be 0.0004. What is the 95th percentile of the benzene from that distribution? And they went and did that for each of these lines.
Right. So this particular type of plant, and I understand it's limited, they did 78 tests on 19 facilities.
That's what
was 78 runs.
78 runs reported benzene emissions from 19 different facilities. That's correct.
Okay, gotcha. I just want to make sure that I'm understanding what this document does. Okay, thank you so much.
Sure.
And here they in this area, and again, I'm a little in over my head here, but I'm going to go ahead and give it a shot anyways. We have what looks to me like their statistical approach, how they ended up doing this. And I have a couple questions for you because I'm a little confused about this. Like literally, this isn't rhetorical confusion.
No, that's okay.
Go ahead.
No, that's okay. I'm listening.
So now there's a phrase in here about the population. My eyes are really bad. I need to get up close here. Sorry about that.
That's okay.
Okay. So there is a hypothetical population. What does that phrase mean? It says that this study is using a hypothetical population. Is a hypothetical population relating back to those 19 plants that we're using?
Yeah, so let me describe what they're doing. It's a technique called, as they call it, it's called the Monte Carlo technique. What they're doing, Mr. Vail, is let's say you have a distribution, take that benzene distribution of 78 different individual data points they got from 19 runs, so 19 plants, right, in that example that we had. So that forms a distribution. What they're saying is that is a sample that came from the larger population of all the plants. Of course, there may be more than 19 asphalt mixed plants that have, that are out there in the country. In other words, anytime you do a test, that is a sample, and you want to see how well that sample represents the underlying population of all plants, that even the ones you didn't test. Are you following? So, and to do that, what we do is a sampling. In this case, what EPA did is they said they did a Monte Carlo sampling. That means within this distribution of these 78 data points, they've essentially fit a distribution. I'm going to use a Gaussian, kind of a bell-shaped distribution as an example. It doesn't have to be that way. But they created a distribution and they sampled that 10,000 times. That means randomly. So that is supposed to represent the underlying population had they tested every single plant, not just the 19 that they did, but every single asphalt plant that had benzene. They would have gotten much more data, of course, right? And this way of doing a Monte Carlo mimics what they may have gotten. Taking that window of what they did get, they're able to say, this would have been the bigger data set if we had more sampling from everybody else. That's what they're trying to do here.
And for the study, there was a number of assumptions and decisions that were made, in any kind of study, none of them, and this is not a knock on this study, but any kind of serious study that's peer reviewed based on data, none of them are perfect. Can we agree on that?
Well, we can, and that's the whole point. Is one of the most imperfect things was the indiscriminate use of AP42's average factors. They're trying to correct that and say that let's make sure that we don't have that big correction first. So
yes.
I'm with you.
Right. And on this particular, for this particular document, what they said was they assumed that the data that they had available in the example I used, the 19 asphalt plants in which they did 78 runs, they assumed that was a representative sample of the population of interest. Right. So that means that it doesn't mean that it is representative. It just means that they assumed it was representative. Is that correct?
Yeah, and I'll go further, but they made that very clear from the first sentence. They said, we are only looking at just the A-rated samples, okay? They purposely biased the work here to look at uncertainties really under the best, least sort of, problematic data that is in AP42. That's what they tried to do and inferred these ratios even under that circumstance.
And they said, furthermore, we decided to disregard any precision concerns regarding the difference in number of test runs comprising each emission test value used to calculate the emission factors. So, in other words, maybe my understanding of that is that, they're doing the best they can. It's not a perfect study. They're trying to get as close as they can. And in order to try and get close, they had to really disregard concerns about precision that may have made this study too unwieldy. Is that a correct assessment of that?
I think that's overreading that. That simply means when you do a test, typically you do 3 runs. Sometimes you might have 2 runs. Sometimes you might have 4 runs. They're simply saying that they recognize it's typically 3 runs. But if they're, for example, there may be a duplicate run, or there's a run that was repeated for some reason, they may have not taken that into account. But again, don't lose the big picture, which is all of this was for those A-rated factors for which we're supposed to have best data. And unfortunately, in the AAM permit, we were using D and E rated data for which, these uncertainties would get even worse.
Thank you so much for that. Okay, so this document was released in February 2007, which means that and then I'm not saying this impinges on its reliability or accuracy, but this document is going to be having its 25th birthday this year, correct?
2007.
Or just did this month, right? This month, 25 years old.
Well, 2007, and by my count is 15 years, but maybe you were adding.
Well, 2007. Look, math has never been my strong point. Okay, 15 years. Thanks so much. Okay, so So this document was released in 2007, and here's the EPA statement on this document.
Sure.
And would you mind reading the highlighted portion of this? And this was released in October of 2007.
Well, there are two highlights. You mean both? Everything?
Yeah, yes, please read both.
Okay. Since the posting of the draft emission factor uncertainty assessment for comment on April 24, 2007, we have received numerous inquiries from interested stakeholders questioning whether the agency intends to include the effect of uncertainty on a source's applicable emission-related requirements, or whether states or local authorities need to apply the effect of uncertainty to determine area compliance with NAAQS standards. As originally stated in the draft assessment, we do not attempt to evaluate or provide guidance on the application of emission factor uncertainty in making environmental decisions. Moreover, any such decisions would only be made after formal notice and comment rulemaking process. However, EPA did not intend any change in current practices that would warrant rulemaking. Rather, our intent is to educate sources and regulators about the accuracy of the emission factors and to provide such accuracy through the incorporation of the results of direct emission testing into the estimation of future emission factors.
And Mr. Hearing Officer, this is NMED EIB exhibit number 30. I apologize for not announcing that. So this is my last few questions, Dr. Sahu, and I appreciate your patience. So as I understand this statement is that, and I'll ask you a couple questions. Basically, the EPA stands by this document, but as an educational document for regulators, for regulated entities, and for other interested persons trying to kind of understand the uncertainties with regard to AP 42, insofar it applies to these sort of large statistical models that we were talking about. Is that correct?
Let me clarify that a little bit. What EPA is saying is they're not going to go through rulemaking to make this a rule. That's all they're really saying. I mean,
I see.
It's a formal process. They're not making a rule. So that last sentence is very important, which is their intent is, to, as you said, to educate sources and let people know and regulators that about the accuracy of emission factors and how that accuracy can be improved by incorporating these direct emission testing. You know, where you have an opportunity, you do your testing. Because otherwise, you have these large errors. They're simply saying we don't want to go through rulemaking. I should point out, for the benefit of the board, entire AP 42 has never gone through rulemaking. Okay. So it is in the same part. I mean, none of those things have gone through rulemaking. So this is all left up to people who are going to use their technical judgment and do the right thing by not inappropriately applying what is intended for one reason somewhere else and not being mindful of the errors.
So this document is not EPA guidance, correct?
This document is, I wouldn't call it guidance. It was just analysis of this A-rated factors uncertainty.
And this document has the uncertainty assessment and its conclusions, to your knowledge, ever been? It's been 15 years. I said 25. Sorry, but it's been 15 years. In that 15 years, to your knowledge, have any rules been promulgated that incorporate this uncertainty assessment?
No, EPA has not done that. EPA has not done anything to make its AP 42 guidance or rule either. And so they are just out there for folks to use as they see fit and subject to all the uncertainties if they misuse them. And EPA saw a lot of that is happening.
You're cutting out. We'll wait for Dr. Sahu froze on us, I think.
Yeah.
Dr. Sahu, you froze on us.
Oh, I'm so sorry.
I'll let you finish up. I'll let you finish up if you'd like.
Oh, I'm so sorry. I didn't realize I was having dead air here, but can you hear me now?
The last 15 seconds. Oh, yeah. It was about the last 15 seconds.
Oh, I just said that EPA hasn't gone through AP 42 rulemaking either. And so it is in the same par. It is basically their compilation of data for users in the air pollution community.
Okay. Thank you, Dr. Sahu. I have no further questions.
Thank you, Council.
Okay. Do we have questions of Dr. Sahu on his rebuttal from the public, members of the public? Okay. Are there questions from board members? Questions from board members? Not seeing anybody raise their hand. So I guess that takes us, Mr. Jantz, to any redirect you may have.
And Mr. Hearing Officer, members of the board, I'm pleased to share that I will not have any redirect of Dr. Sahu.
The hearing officer is pleased to hear that. I think that takes us to, that concludes the testimony in the proceeding. And that takes us to discussion of post-hearing submittals and other post-hearing matters.
Mr. Hearing Officer, I presume that I can leave the proceedings, right, as witness?
Oh, I'm sorry, you're excused, Dr. Sutton.
Okay, thank you.
Thank you for your testimony.
Thank you all. Bye-bye.
So we're going to discuss post-hearing matters and submittals. And the first item I have on my list is preparation of the transcript. You may have noticed, I think I neglected to mention that we have not had a court reporter for the next 2 days. I think I mentioned we might not have one. Well, in fact, we haven't had one. And so the intent is to use the recording, the WebEx recording of the proceedings, backed up by a secondary recording that the department has done of the proceeding, provide that to the court reporter and have the court reporter work off of those two documents to come up with a verbatim transcript. And I'm not sure if anyone at the department, I believe Mr. Vigil was at least at one point the point man on this, point person on this. I don't know if we have any more information from the court reporter on when we might expect a transcript. Do we?
We've been told that the court reporters have agreed to a 30-day deadline. You know, typically it takes less time. I'm going to go ahead and, stick with the 30-day deadline, but I've seen them come in on about 3 weeks. This is a unique, proceeding because of the technical nature of the testimony. But yeah, I think, they agreed to a maximum of 30 days, and we will follow up on that. And counsel and the hearing officer and Ms. Jones are welcome to knock on my door anytime if they feel like things need to get moving a little bit quicker.
Okay. So working off of that deadline, this is just a suggestion at this point for discussion by the parties and by the board, most importantly, that we provide for closing arguments, briefs, and proposed findings of facts be filed within 30 days after the transcript is filed. The hearing officer report and recommended decision will be filed 30 days after that. And then the board will schedule its deliberations as it sees fit after it receives the hearing officer's report. We will have, I'm suggesting 15 days for comments on the hearing officer's report and recommended decision by the parties. And then once that period expires and those are received, the board can set its schedule for deliberations. It might be that after the comments are received, I might want to prepare some revisions to my report, but I'm gonna defer a decision on that until I've looked at the comments. Does that do folks have comments on that proposed or suggested schedule?
The department thinks that's reasonable. The department thinks that's great. No problem.
Okay.
Yeah, Mr. Hearing Officer, petitioners agree that's reasonable.
Okay. Hearing concurrence with my suggested schedule, we will follow that. And one other housekeeping matter, we have public comment scheduled for 5 o'clock today. The hearing is going to obviously wrap up before then. I'm going to ask the host if she would continue to monitor, keep the meeting open and continue to monitor for requests, both on our email and in the chat room, and just inform anybody who indicates they want to make a comment to ask them to please make it in writing at this point. And so we'll take any comments that the public wants to make during the 5 o'clock session in writing, given the fact that the hearing will have adjourned.
Yes, sir.
Mr. Hearing Officer, and Ms. Jones, please don't kill me for saying this. You know, it's been the practice in the last few months, if not longer, that we reopen the meeting, not everyone, but that Ms. Jones reopened the meeting like 4:45 to check and see, so that those individuals who prefer to give oral comments can give those comments orally on WebEx. It's just a suggestion. I know it's more work for everyone, particularly Ms. Jones. But I would ask that the department, or excuse me, that the hearing officer allow that, just so that you know, people who were expecting, and maybe people who express themselves better orally can do that. And I would also ask that the interpreters be there as well. We've done that in the past. Of course, that's going to be in a group. Everyone has to agree to that, but I think that's the best, most transparent way to wrap it up. My opinion.
I'm certainly willing to accommodate that. I'm aware of that practice. My intent was to be efficient with how we do this and still let the public comment. But given the request of the department, we'll have Ms. Jones reopen the hearing. I will also be on to take the public comment, and anyone else who's on the WebEx meeting can feel free to join, but at least Ms. Jones and myself will be available to take oral comments at 5 o'clock. Is there anything further? Mr. Honker? Mr. Honker, did you have something?
Yeah, yes, I'm sorry, I was having a hard time with my mute button. Could you run through your post-hearing schedule one more time, kind of in chronologic order? So I don't think I caught all aspects of that. I'm just
Yeah, it's a little lengthy. And I will, once the transcript, I should have said this, once the transcript is filed, I will issue a written schedule with firm dates. So this is just to give, you know, general guidance as to deadlines. So the deadline for the transcript is 30 days from today. Mr. V. Hill has indicated it might be earlier. And if it is, we'll start the remainder of the clock running from then. Closing arguments, briefs, and proposed findings of fact and conclusions of law will be filed 30 days after the transcript is filed. The hearing officer's report and recommended decision will be filed 30 days after that. That is 30 days after closing argument and briefs, etc. 15 days after the hearing officer's report and recommended decision is filed, comments will be, if any, will be due on the hearing officer report. And that will conclude basically the post-hearing submittals of the parties, subject to revision if it's deemed to be appropriate as we go through the process. And then once, and I may decide to revise my report after we get the comments. And I'll impose a deadline on myself for doing that once we get into the process. And then after that occurs, after I either revise my report or indicate that I'm not, the board will adopt its schedule for its deliberations and decision.
Okay, that's very helpful. Thanks.
Yeah. And as I say, I'll provide a more detailed schedule once we get the transcript, so people will have firm dates for those items.
Mr. Hearing Officer, is it possible, and this might be a question better suited for the department, but for petitioners to get a copy of the WebEx video before the transcript is released? Can the recording be shared with everyone?
Yes, I'm to send that to you as soon as it's. I've got 2 days, and today's meeting will it'll conclude at 5-ish, and then it takes WebEx a couple of hours to send me the link, and then I'll send it on to everyone.
Okay,
And
great.
I would
Thanks,
say that once you get that link, I'd give it a good 12 hours to load up because it's so big. It really takes a lot of time. Pam gave me or Ms. Jones gave me the link, and I couldn't unload it for like 12 hours. So let it sit overnight. That way you can get them.
Okay, thank you.
Okay. Is there any further questions or comments?
Mr. Hearing Officer, this is board counsel. For your own planning purposes, I just did a quick kind of calculation off the flat cuff here. The board has a meeting on June 24th and July 22nd. So I believe, if my math is correct, that the closure of the comment period would be June 17th. That may be a little tight to turn it around if you're going to revise it for the June meeting. But I also wanted the board members to be aware that that's really going to be your deliberation window, is going to be either the June or July meeting.
Okay, thank you for that, Council. With that, the meeting is adjourned, the hearing is adjourned, and thank everyone for their participation.
Thank you, everyone.
Thank you.